She walks it loud like a thunderstorm, debunking myths with style and form. True crime, conspiracies, her game. Melissa Jade, remember her name. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa Jade, she's got no shame. Microphone fierce like a roaring lion, unveiling secrets people been hiding. True crime queen of the digital scene, Melissa's got you hooked on her screen. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa Jade, she's got no shame. Murders to cover-ups, nothing misses. Melissa's here to share her guesses. She's got theories big and bold, no stone unturned, no case cold. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa Jade, she's got no shame. Melissa Jade, she's got no shame. Melissa Jade, she's got no shame. From murders to cover-ups, nothing misses. Melissa's here to share her guesses. She's got theories big and bold, no stone unturned, no case cold. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa Jade, she's got no shame. 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 She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa Jade, she's got no shame.
Hello, everybody. Hi, Shay Benet.
Hey, Melissa Jane, everybody.
Hi. I've missed everyone. Hi, Samantha. Curious Christine. Holly. We have Wolfie. Hey, you dirty little thief, you. What did you say? Oh, shut up. Hi, Claudia. Hi, Harlot. People me. We got Neat Noodle, Katrina, Mallory, Rebecca, Pointer Lover, Being Bio Girl, Morale. Did you change your photo, Morale? I feel like you did. I like it. We have Fragile Like a Bomb, Tony, Sally Mae, MS Girl from the Laundromat. We got Neat Noodle, Michelle, Kimberly. That's awesome, Kimberly. We have Harley Quinn, Kelly Renee, Margaret. Hi, Lisa, Shelly Bean, Sherry, Vanessa M., Sharon. Hi, Sharon. It's been a minute. Ruffian. I'm trying to get everyone. Midnight Lays. Val. Hello. Because once you get like a certain portion through, Shay, like as a creator, like this is how my mind works. Once you get more than 10 names in, you're like, well, now you're invested. You have to say literally hello to everyone. You know, you can either do a couple and then say hi, hello. Or once you get past about that 10 name mark, you're like, now you can't, no turning back. You're invested. You have to say hello to literally every single person in this chat because you don't want anyone to feel excluded.
No, I could totally understand that. I would probably be doing it forever.
Neat says, I've been waiting for this, Shay. I love your thoughts on PK.
Oh my gosh, no, I love to hear everybody's thoughts and Melissa's too, because we do think very differently a lot in some things.
Hi, Cat111. It's been forever. Angel D. Homer says he's excited. Hi, everyone. You guys. Ooh. We have, oh God. And I was just talking to Shay backstage. Like, we're going to have to pick up this Idaho coverage because honestly, we're getting so close and so much continues to come out, and like once, maybe twice a week's just not sufficing it, even though I know me and Shay are super busy, but I'm like, I want to try to push forward as much as we can with Idaho because this is just I don't know, like there's not in the true crime genre, like as a creator, there's every case is very unique and every case is very interesting to follow. But not every trial you go into, everyone has a very unique, different set of circumstances, obviously, you know, but not every time will you get these type of questions going in, feelings going in, that following it for years to still kind of be so much in the dark with things. That I'm very eager to be going into this trial and watching it unfold, seeing the process with prosecution, seeing the process and strategy with defense, and see what the answers are while getting these victims the justice they deserve. And so I'm just so ready for this.
Amen.
Yay! Thank you, Amy, for 9 months. We have an MJ baby. Hi, MJ. I'm so glad I found your channel. Me too, Amy J. All day, every day. I've missed you all. Hey, Rebecca.
I think you were really missed the last few days, Melissa. I'm really
Well,
looking for you.
To be fair, the last time they saw me, I had to, I made a boo-boo and I showed something I shouldn't have showed. And I had to like shut down my whole stream and private it and then like get up another stream, but then private that stream because I spoke about what I showed on that stream and I just didn't want that out there. And so I've gotten even emails, people thinking they've been blocked because if you're watching a stream in real time and like it goes private, you know, like it just turned, but not everyone's familiar with that. So a few people thought since I hadn't been live and that was the last time they've seen me live that they've gotten like blocked or something, you know, that, and I'm like, no, I just haven't been live since I fucked up. That's it.
I get it.
Hi, Chase. I was stressed for me, Lisa. I was stressed for me. And then I woke up the next day with my debit card, which I'm pretty sure was just straight coincidence. I know, but I woke up with my debit card being used in another state, which I have no idea how. And what the strangest thing, Shay, is that it's in Greensboro, North Carolina. And I obviously called, right? And was this over the phone? Like how did this? No, it was used in the store. Now it couldn't have been my card because I have my card, right? So I don't know if they gave the numbers or something. But I swear, like, there's no way it correlated to what happened the other day, but it's crazy timing. So I had to shut down my card, cancel it, get a new one, you know, start the whole dispute process. It's been lovely over here. How have you guys been?
Oh, I'm so sorry to hear that. That is very stressful.
But you don't even know what happened at last night. I'll tell you about that later. But yeah, it's been a mess. It's been a mess. But we're here now. We're ready to do Idaho. Put a 17 in chat if you watched the most recent hearing. It was 100 and I think like $20 something, $120 something, which sucks because it's like money, but like you can't start the actual dispute process until it switches from pending, even though when it's pending, it still took your money. But like all my transactions stay pending for like a couple of days. I don't know why, but you can't start the actual dispute until it like switches over, and it still isn't switched over. And so I still have to sit here and wait. But yeah, either way.
Wow. Well, I hope they get everything worked out for you.
Yeah, me too. And to the person who went to like bought themselves jeans, because it was a retail store, it was just a normal retail store, with my information, if I don't get a new pair of jeans myself, you don't get new jeans on my account, okay? Bullshit. I don't even get new jeans, and it's my money.
I feel you on that.
Yeah. Okay. Oh, hi, Miriam. Hi, Hazel Eyes. Hi, Perpetua, Sarah. Hello, everyone. All right, so hold on. I see a decent amount of 17s. Neither me and Shay have had a chance to watch this yet, so we're going to be going over it all in real time with you guys. We're going to go over these documents. We're going to kind of jump over what happened at the hearing. We're going to get into all of it. Oh no. Are you saying it's going to take that long to reverse my money? If this bank, this bank, I'm like, I wish they did it to like the normal bank account, because this bank is a virtual online banking. Like there's not a physical store. Like, I don't know why I'm slamming that, but like, it's not like I'm not a store, a physical bank. It's all one of those online banking things. And so everything is just much harder. Oh, no, 2 tickets. All right, maybe I'll just accept the jeans. That is, how expensive was that, Pointer Lover? Yeah, if you don't get to go to France, nobody gets to go to France. That's crazy.
Damn, that's expensive, I'm sure.
Yeah.
It's in the thousands.
Hi, so there's that. Yeah, it really sucks, FOS. So I'm not even relying on them to return my money. Like, I just anticipate something just to not work out.
It'll work out. Just give it some time.
Holy moly.
Oh my gosh.
Huh. Okay. So let me just start with our missing child for tonight's live stream. Our missing child is Diana Therese Nicole Wynn. I love this photo. Can I just say, she looks fabulous. I think, yeah, it's a school graduation photo. I don't know. It's a great, every school photo I have of me does not look like that. Because they
graduation?
Usually, you can see the little cap. Look at the little cap.
There's a
with
cap?
The tassel.
What would she be graduating from? She's 14.
Middle school, maybe? Look, is that not a cap with a tassel?
Maybe. They have middle school graduations?
They got middle school graduations, right, guys?
I've never heard of that. We only have high school graduation and maybe kindergarten.
Well, either way, she looks so mature. She is 14 years old, guys.
It's beautiful.
Absolutely stunning. Beautiful girl. She's been missing since May 3rd, 2025 out of Jersey City, New Jersey. 14 years old. We have an additional photo showed of Diana. She may travel to the Bronx, New York. So here we have another photo, which she looks way different. I know her hair is different, but she looks almost younger here. Probably is, I'm not sure. But very, very, very beautiful girl. So if you or anyone who knows information on her whereabouts, please contact Jersey City Police Department at 1-201-547-5477. Yeah, you know how I know they have we had middle school graduation, Shay? I'll tell you a quick sidebar story. Me and my friend, Busty at the time, got dropped off at the beach. 2 days before, no, it was probably like 3 or 4 days before. It was the weekend before our middle school graduation. And we thought it was a superb idea on like a UV index 10 type of day to take baby oil, because we wanted to get, color, because we didn't take the time to prep ourselves and just work our way. We wanted like overnight. We wanted to be, beautiful. And so we smothered baby oil all over ourselves and we cooked out on Jones Beach. And then I knew it was bad when my mom picked us up. And as soon as we got in the car, like, she was like, what the fuck, And I didn't realize, just how brutally burnt we got. And then that was the first and last time I got severe sun poisoning. And it bubbled up. I have scars to this day from this sun poisoning. But fast forward, my beautiful photos from my middle school graduation, because eventually, even if that burn turns to a tan, what happens? Do you know what happens? It peels. So, but did mine peel normally? No, I had a beautiful brown face, but right down the strip middle, like your T-zone, that peeled. And my normal white self underneath that peeled hair. So I looked like a janky brown cow on my middle school graduation photos because it was just brown on the sides and then all white peel down the middle. So, yep. That's my middle school story.
Oh my gosh.
Very much no. We have, and it was a blue cap and gown. I know what I was wearing. Okay. So yeah, we have middle school graduations here.
Oh my Lord. I've I've had some bad sun poisonings, like second degree burns, but when I've had like an event after like getting a bad burn, like say like gone to Mexico a few times for like weddings, at the resorts they have like these sun like burn therapies you can do, and they take all the redness away from you and you don't get that like peel like for that event. But if they only had that everywhere, because it's the only place I've ever found it.
Honestly, if I could go back to my younger self and like, I just think it's funny, and I'm sorry, I know we're getting so off track, but I just think it's funny because the generation today of kids versus the generation of us. So us, we used Sun-In. What the fuck, Sun-In? Sun-In is literally like bleach that we sprayed to our hair to acquire platinum blonde, aka orange yellow streaks. We used Dream Mate Mousse, where we had a distinct line between our face and our neck, okay, where there was just that harsh, no blending. There was no beauty blenders. It was just wow, okay. Then we had the baby oil. We had all different, and then you see kids now who have better skin routines than I do. They sit there on their TikToks, and they're like, this is my bubble up, and this is how I do my face nightly routine. And they put like their gorgeous little headband on, and they start doing this skincare. Like they look so much better than like we were a mess. You turned around and you could see the tracks of my clip-in extensions popping out. Like we differed, okay? We live in two different worlds. So
Well, and even to think about like makeup, like these kids know how to do makeup better than I do. And I just remember getting like 17 magazine and seeing like an article about how to properly do your eyeliner or pluck your eyebrows. Like there wasn't like YouTube videos and stuff.
yes. Oh my, yeah. Like you knew you were fancy if you had the Playboy white spot, because first of all, those were supposed to be like to cover up moles and dangerous things. We just used it as I'm going tanning. Obviously, you want the Playboy bunny on your little what is it? Your whatever bone that is. I don't know. I haven't seen mine in a long time. What bone is that? Your hip bone, your pelvic bone.
Yeah, your pelvis.
So like, you knew you were fancy if you had that type. The rest of us had to like slather the damn Jensen. What is that called? Jensen glow.
The self tanner?
Yeah, the self tanner shit. And in between your fucking fingers would look like hell. Like it would literally look like what's at the bottom of a toaster oven after cooking meat or something. It was gross. Oh man.
I managed like a tanning salon for like 6 years. Like I grew up working in tanning salons since I was 14. Yeah, like, but even though I worked there, I didn't tan all the time, but I did want to learn how to do the self tanning because that was getting popular. But it wasn't perfected like it is even now. Like we were still like super orange. It just brings me back to like Laguna Beach days.
Laguna Beach. Oh my goodness. Yes. They say everyone knows. Yeah, JK, the Jergen self tanner. Yeah, I know. Whatever that bone's called.
Do people still tan?
Yeah, well, no, I think the new thing to do is the spray tan, and now they literally have the ones in their own house. Like they have like, time to go tanning, and they like open up a room next to their bathroom, and it's like, wait, what's that? Like they have a whole room just to tan. They have the machine and they spray it, and I'm like, damn, it's a whole different world.
Absolutely.
Okay. All right. So here, let's get into it. Sorry to get sidetracked. Please hit the thumbs up if you haven't already. Thank you all so much for being here. I'm so excited to go over this with you, Shay. So let's start looking at, we have Kohberger here, and we have some new documents uploaded. Okay. Ooh, I want to go for it. So I immediately see. So at this most recent hearing, the two things that me and Shay are pretty much aware that happened aside from, the jury selection is the alternate perpetrator. And then Judge Hippler, from what I'm understanding, is not happy regarding this leak. And so the last Idaho episode we did was on the Dateline episode, and there was a lot of information that came out. And the question is, where did this information come from? Who is giving this information out? And I have a feeling, Shay, that this isn't information that's just being leaked now. I feel like it had been already for the most part. And why it's coming about now in a Dateline episode, I'm not sure. What do you think?
I think that there's a lot of the storyline, like you said, that we've heard of since a couple years ago. But I think like maybe piecing together some of that storyline was more apparent on Dateline. But I think the biggest thing for me was the stuff allegedly is Brian's extractions from his phone, you know?
Mm-hmm.
That was probably something that I hadn't really heard, but had we heard about a
Yes.
pool party? Yes. Had we heard about certain little things? Sure. But that detail that maybe would have come from those search warrants, like, no, I was not aware.
There was a lot of information allegedly that was contained within Brian's phone that I am struggling with. How did that get out? And I now listen, I am not upset that I found this information out, but do I think it's right or fair? No, I don't think that that was right or fair. And I feel like we got so close to trial. It wasn't right. Not saying that a leak would be right, but I feel like, oh, come on. Like, the general public did not need to know this close to trial. And I do think that I feel like I could bounce back and forth, Shay, because I look at other cases and I'm like, oh, there's been massive amount of information the general public has known before we hit trial for that person. But in
Hmm.
a case like this with such a tight gag order, I do not feel like it was necessary for the general public to know this so close to his trial. And I do think it's unfair towards him.
I I don't know. I'm hit or miss. I think that if the gag order wasn't in place and some of these details were out there for the public, then that's one thing. But because of the gag order and where we're at, yeah, it does seem a bit unfair. However, I will say this, that we talked about like what was coming out, like were some things like new or shocking, you know, and no discredit to some of the authors that have written on this case, but there's one thing reading airmail, reading a book, but Dateline, I feel like holds a lot of credibility to people and the masses that have watched it over the many years it's been running, that I think it was like putting it was putting it out there in a larger way that people felt like they found credibility in those said rumors or stories that had been kind of stewing about. What do you think?
I think I can see that, but I think that the people who are set that there is a conspiracy going on and that Brian is innocent
Mhm.
are very confirmation biased for the most part. I won't say all, but from my interactions personally, I am seeing such extreme confirmation bias that it doesn't matter what information is shown. It's not like all of a sudden, oh, their concerns are going to be settled, or they're going to, oh, okay, maybe he is the guy. And at the end of the day, the only people whose opinions matter are the jury of the 12 peers that's going to be judging him. So again, I'm not angry that I want all of this information, obviously, but when I'm looking at it in regards to Brian's right to a fair trial, I will say that that wasn't necessary, and it felt,
I
I
think the
don't,
phone records and stuff was too far.
that absolutely. If it was just general information that, let's be real, we've kind of heard along the way, like you said, okay. But as far as all of that information, what was in his phone, I feel like I absolutely believe they'll be able to find a jury, no problem. But it wasn't necessary. We're so close to finding out this information anyway.
Yeah. And I saw this little clip with like Brian and he like said I think he said he reached out to Bryan Kohberger personally to see if he would comment on any of it. Oh wait,
Oh,
no, no,
really?
no, 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 it wasn't Brian. Excuse me. I watched Ken Main's Unsolved No More. I'm sorry. I went and watched, like, he did a video. He doesn't do videos often unless it's like certain cold cases he's covering. And he said that he reached out to Bryan and asked him what was of interest in his Ted Bundy series that he watched. And he said he understands if due to where he is at in his court, process, that he can't speak. He's not asking that like of right now, but he wants to know more. And I thought that was kind of interesting. Sorry, said Bryan, but it was Ken Means that said that. I was like, I wonder if he'll ever respond to Ken.
I like Leon comes in with a little curveball here and says, I lean on the defense team being involved in what's leaked. This is a solid case, in my opinion, and Ann Taylor knew it. It's all for profit for some. Shay, do you think there's a possibility that this was a leak on the defense side themselves?
I don't know. I mean, I think it could be in part maybe some information, but not all, because I think you and I both know that there's some of those stories, not Brian's phone records, but those stories we've heard about from grand jury leaks, and that's been going on for a while.
That's true. That's absolutely true. And for anyone who doesn't know what she's referring to, this goes back years earlier on, very early on. Oh my, it was 2023, right?
Mm-hmm.
Early 2023, it was coming out that there was a grand jury leak, possibly two grand jury leaks. And this is why we have to kind of go back in time, because we have so much information stored, and go through and kind of, I know specifically, Shay, we have those text messages about the grand jury. And so I really would like to go back over that.
Yeah, absolutely. I'd like to too. So I think it could be like you said, like maybe there is a. I don't really see really who benefits from any of it, honestly. Like,
I agree. See, and Kelly says, what would the ramifications be if it's found out the defense leaked it? Okay, so let's just for a second say and play devil's advocate. It was the prosecution or it was the defense. What would happen here if they found out, if Judge Hippler found out either state or defense directly was part of the leak? Now, I think immediately back to Richard Allen, right?
oh yeah.
And we had a leak. You want to explain what the leak was?
We had two leaks that happened. But the one of the former that came closer to trial was after the Franks hearing motion was filed, and it was the alternate perpetrators that Richard Allen's defense team put forward. There was a leak apparently that somebody that one of the defense lawyers knew had been up at their office. They had a what they call like their war room where they work with, on the case, and there was stuff out there that they felt like it was possible that somebody they knew took pictures of some of that and circulated information, even pictures of the girls as they were found. And then they looked into that, and one of those people is not alive anymore. The other person, I believe, was being arraigned for that. I haven't followed back up on where they're at in that process, but my understanding is that they do in this case, which I know we'll get into more, like a special prosecutor in determining who did it. They could possibly face charges, but if it's like a lawyer or one of them, I mean, the judges could take, different avenues just depending on what their state law is.
Right.
I don't know if I answered that best for you, but
No,
like,
but you
yeah, there
did.
was repercussions for sure. Oh, and they pulled the defense lawyers. Excuse me.
Yes.
I didn't get to that part. In the Richard Allen case where they felt like the defense lawyers are being negligent, they pulled his lawyers off the case, and Judge Gold did that, and that's not what Richard Allen wanted. So they put in other defense lawyers in that case, and then the defense lawyers hired their lone lawyer to work up the system through the courts to get them back on the case. It was very, very messy in a time where they were getting ready. to try to go to court very quickly. And as a defendant, you have a right to your attorney, and Richard Allen wanted his defense attorneys.
Yes. Now, if it was an attorney, let's say Anne or someone from the state side, and you had the client who was not happy, like, as far as like Richard wanted his lawyers to stay on, kind of similar to what Samantha just has said, they could be held in contempt, they could get sanctioned, a lawyer can get in trouble, absolutely. But it seems like each judge, their courtroom, even though there are regulations and a set standard that they have to follow, but each judge's courtroom is their courtroom. And so it's really how each judge themselves would want to handle it for the most part, like as far as gray area, yes, there's like black and white, but their courtroom is their courtroom and they run the show.
Right.
Hi, King Scarlet. All right. So do you guys want to get started on this? So okay, let me see. Where did we last leave off? Mitigation witness list, 5-9. Okay. Is it the 13th?
Yeah.
Okay. All right. Well, I'm jumping to it, Shay, because I need to see it. I need. Oh, it's so short. No, come on. All
I
right.
think they're each a couple of pages is what I saw.
So this is, oh, okay. Well, why? Yeah, of course. Why did I say it was just a ceiling? All right. So this is the motion to seal defendant's offer for proof for the alternate perpetrator. So come now, Bryan C. Kohberger, by and through his attorneys, moves the court for the order to seal defendant's offer of proof for the alternate perpetrators filed on May 14th. So what we understand from this hearing is, because there were a part that was sealed and a part that was not sealed and open. Well, sealed, aired private, held privately. Anne has submitted alternative perpetrators. But from what Judge Hippler said is, you're going to have to give me more. So similar to the alibi and that first alibi we got from defense. And it was very general, just out driving at night. I can't tell you where, can't tell you when, just generally out driving. Well, that doesn't meet the alibi standard, right? And then they came back with the next, oh, well, he was driving at this time, stargazing, he liked to go hiking, blah, blah, blah. So it seems like very similar to the alibi. We now have an alternative perpetrator that Anne is putting forward in a very black and white, without any additional information type of way. And Judge Hippler is like, you're going to have to give me more. Like I see that you filed, right? But you're not giving me anything with it. So what are your thoughts with that, Shay?
Yeah, I mean, I agree. Like, if it just depends on what strategy the defense is doing. If they're looking to open the door to name alternate perpetrators based on whatever Idaho's law is, I don't think they would. I don't know if they would do third party culprit, but yeah, I mean, you'd have to put forward a good proffer for that of information for the judge to consider, and he doesn't feel like there's enough for that. And I don't know what it is because it's sealed, but I would agree, like if you're going to throw people's names out there, you better have good backing on it because it can change their lives significantly. We've seen it in different cases in different ways, from Delphi to Karen Reed. Whatever your feelings are about it, it does change those people's lives. And I think also I've heard that like the judge also, and I haven't watched it as well, but I heard that he also emphasized that Dylan and Bethany are victims. So I don't of the robbery. So I don't know if like what she would put forward, but I heard there was a name. I just don't know what it was. And I heard that like I think on a Brian Inton's like little Twitter thing, but I don't know much more about it.
He emphasized that Dylan and Bethany were victims at the time that they were discussing the alternate perpetrator?
I don't know. I've heard those things be talked about in tandem. So that's why I'm looking forward to hearing the court hearing with you to see how that information came about. Because that I don't think that they're put forward as that, but maybe that is something he stressed to them because there has been a lot of talk and buzz about them. And
Okay, then I
you
guess
know what I
we
mean?
gotta just go for this. Let me grab the hearing.
Sorry, I don't mean to be like so elusive, but I that has been discussions that people are having in a public forum, whether they're understanding of their information fully. I don't know. I haven't seen it yet. I'm curious.
Okay.
Yeah, I did. Yeah, I did hear he was going to give them seats in the courtroom, Kristen. Yep. And I also heard he's going to give them the option if they want to be on camera.
Okay. Let's take a listen.
Can, can I? Oh, no.
Go ahead.
I was going to say something about the leaks thing, like whatever. I'm kind of
Yeah.
curious what like I don't know what Judge Hippler is going to do. It sounds like he wants whoever like did that to take account for it. I don't know if that information will be made public to us because it was like my understanding, like a separate
It's a
special prosecutor
parallel crime. Like it's gonna be a parallel case. The way that
right.
sorry, I have kept in my head parallel crimes. No, it'll be a parallel case. You're right. We probably will not get. It's not like it's gonna happen within this case, guys. It's gonna be its own case. And there he's bringing in special prosecutor. He does not seem happy, and honestly, in a way I'm happy that he's doing this because it isn't fair. Leaks aren't fair.
And frankly, like if you have reporters and journalists, like, they have some of their own protective laws, like that they work under, and they typically don't have to hand over their sources. So I don't know if going to Dateline and them, giving those up is going to be the option. I have no idea. I'm very interested to see if we will find out how this plays out.
Right. Okay.
For both sides previously identified are present. We are in the public session now. I have.
So again, remember the first half of this hearing was private, and now this is public. So they've already been here and they've already discussed things. Oh, Bryan got a haircut, Shay.
My own agenda for what to cover today in the pretrial motion.
Nice.
So,
Whoops.
I'm not sure what you have. I didn't receive any specific motions.
Look at Joshy
covered
too,
today,
looking
other
handsome.
than, I think, the ones
Yeah,
previously
we
submitted
got.
by defense.
I said it right before he was added on. We need a good looking. We need someone spiffy at the state's table, man. And look what we got there, front and center, right in the middle, looking good. He's got that baby blue. I'm liking the tie. It's drawing my eye. That rhymes, but I'm here for it.
Oh, and why is our other prosecuting lawyer sitting behind the prosecution? Do you notice that?
Yeah. You know why? Because Josh is here now.
It's
That's
like move over. Josh is here in the building, man.
Yep, that's because again, look, they're wearing opposites. We got Josh wearing that navy blue with the baby blue underneath. That's because just one little navy blue tie doesn't cut it, Shay. Because look at the rest of his outfit.
I know, and it's the hair, the glasses. He's spot on.
Mm-hmm. He's looking good.
And so people who are following the case, like William Thompson, we like nicknamed Santa. And then there's Joshua Hurwitz, and then Ashley Jennings, and then behind
Jennings and Santa Claus prosecutor,
and then Jeff Nye, and then we got on the defense Bika Barlow, Alyssa Massith, and then
yes,
Ann Taylor, and then still I know some people had asked about our dude, what was his name?
Ask
Oh,
about.
Jake Logsdon, Jake Logsdon.
Oh,
He
okay.
he's not going to be on the bench for trial, but he's still advising behind the scenes with the team. I think he took on like a new role with the public DA in Latah County. So he's not sitting with the team, but he's still advising them because he's still included on a lot of the motions.
Right. I think that he's being guided on how to behave. Absolutely. No, I do not believe they are. I don't believe they are. Maybe they are, actually. I don't know. I haven't seen his. No, I've seen him write. I haven't seen cuffs.
About he's got on
Ankles.
he is, I think, isn't he got something to the chair? I remember hearing about that.
I'm not sure about the chair. You might be right. I'm not sure, but not on his hands.
Yeah.
Okay.
I always thought that's why his chair looked different.
Yeah, maybe.
Jury. As I indicated, I don't intend to discuss in the public
Judge
forum
Hippler is always
what
so
specific
low.
questions would be asked of potential jurors.
Hi,
because I
Kevin.
think that inhibits the ability to get frank and unprepared answers from potential jurors. And so we may have to cover part of that in a session at the end of the day. I think we can talk about it generally without discussing the specifics, but if we need to go there, that's what we will do. Apart from that issue, as what I intend to do is kind of break down the trial process through stages. And as you have issues or questions about whether how to handle something or how the court handles something, that's your opportunity to ask as it relates to that phase of the case. And we'll just sort of proceed in that fashion.
Exactly,
So, starting with some general issues, I just wanted, and a lot of this is unfortunately going to sound like me simply lecturing about what I want and don't want. And that certainly is a large part of it, because if you know what I expect, I think it makes your job easier. And so particularly where I can't recall whether Ms. Massoff has had any trials with me or not, but I know she's been in front of me a few times, but the rest of you have not. And so it's, I think, important that you get that information straight from me rather than from the sources that you may get from asking around. So to start with, I'm not a fan of surprises, as you may have figured out by now. I want to know in advance, as far as possible, when there are issues that need to be addressed. That includes evidentiary issues. So if you know that you're going to object to some line of evidence, or you anticipate that there's going to be objections to a line of evidence, I don't want to wait until that is offered in the middle of trial for a couple of reasons. One, I don't have the opportunity to look at the issue to the degree that I would want to in order to give you the best ruling that I can. And two, it doesn't give you the opportunity to make the best case for me that you can for either excluding or overruling any objection. And perhaps even more important than all of that, from my perspective, is in what is already going to be a quite lengthy trial, it just extends it. And nothing frustrates jurors more
he's stoic.
than sitting around in the juror room doing nothing while we're in here doing something. And so that helps guard against that and minimize that amount of downtime that we may have. So we'll have periods, as I will explain to you, before court each day and after court each day, where if you are anticipating issues that are coming up, that's the time to talk about that, not in the middle of the trial itself. I did receive the party's stipulation regarding how to handle the IGG tip, if you will. I'm fine with that proposed instruction, and so that will be given. I think I'd asked you also to work on instruction related to the use of the terms surrounding touch DNA and
this is jury instructions they're talking about, guys.
In the event that I decide to correct somebody about the use of that term. As I said, with respect to the professionals in the DNA community itself, I'm not going to prohibit it in the sense that, you know, I'm going to sustain an objection. What I would likely do is to clarify with the jury, if the parties want me to, about that being simply a convenient title and not meaning to imply an actual source of or method of the DNA being present. And so if you haven't worked on that, please do so to give me an instruction you both can live with. Otherwise, I'll end up drafting one myself, and perhaps neither of you want to live with it. So, with respect to
what?
His comedy is like, I'll end up drafting it, and I doubt either of you want to live with it. He has such snark, and I love it. I'm here for the snark.
I know. I love Judge Hippler. You know what I heard? And again, I didn't watch this yet. So you know what I heard is in here?
Mm.
They're going to mention at one point how they're going to be bringing the knife in. Now, does that mean the knife? Or does that mean one of the knives that they got during the warrant? Because they did from his parents' house. Does that mean an Ashley Banfield example type knife? I don't know, but they definitely mention how they're going to bring the knife into the courtroom.
Interesting.
Mm-hmm.
To the model, I think referred to as the dollhouse by Mr. Thompson. Has that been produced for the defense to inspect?
As Your Honor, it's actually here in this courthouse, has been for a few weeks, and facilitated.
It's in the court.
Yesterday. Okay. It's available for the court's inspection. Well, if the court would like to look at it, and just for the record,
good.
To the extent that the model was characterized as a dollhouse, I think that was an inappropriate characterization. Is an inappropriate characterization. If I'm responsible for it, I assume responsibility, but that's simply not an appropriate way for it to be described, given what occurred there.
Hi, Carrie.
A better term is simply a model, rough model, given that it is admittedly not to scale precisely. So, Ms. Taylor, any record about that? You had a chance to look at it?
Of course,
we did. We were able to bring 2 experts in for our request yesterday, and we appreciated being accommodated while we were here. We do have a remaining question about where the model house will be stored during the course of the trial.
Where are you storing it, on the 3rd floor? Okay. So it sounds like it's stored with the evidence of all the prosecutors down there. And so I suppose if she needs to get access, or our experts do, we can arrange for that as well.
Should have asked a better question, Your Honor. When it's brought in as a demonstrative aid, I am curious about when it's not being used by the prosecutor or the defense and a witness, where it will sit in the courtroom.
I will find some place not in the courtroom, because I don't want it in the courtroom when it's not being used, but nearby in the event that a witness does wish to use it.
Yeah, what knife though, Carrie? Yeah, it's not loud at all. I don't know, Neat Noodle.
The other thing that I would point out, as it sounds like you've been at least to some degree working together, and I appreciate that. As you come to stipulations on things, agreement on things, it's important that those be reduced to writing for your own protection, because too often what I see is in the middle of, for example, trial. Well, Honor, the other side said that they were going to stipulate to that, and then they're not. That leaves me in a difficult position, because I wasn't part of those discussions, right? And so for your own protection, I think it's just important that you get those reduced to writing as much as possible. I did receive the parties' spreadsheets on the exhibits, which we'll go into a little more when we get to the exhibits portion of today's menu.
I like Jury Doodle too.
But I appreciate getting that. There's some questions that I had about it generally.
I've never been called for it.
I've been called,
in terms
but not
of the witnesses.
Actually called.
I had asked, and I think my law clerk reached out to make sure that we get a description of those witnesses, kind of like if they're who they work for or where they're from, something that will allow me to categorize those on a juror questionnaire, so that they don't just get a list of 300 names, but can say, all right, these are witnesses. These people live in Pennsylvania. These are witnesses that work for the FBI. Right, and so that they can put in context those names, which will be result in a more accurate review by them of those names to see if they know anybody. I'm not sure if that's been accomplished yet or not. And so if you haven't done that, please get that to us as soon as possible so we can incorporate those. I think the state had, and last I heard, but it's been several days, the defense we were still waiting for someone from the defense.
I believe that that's been provided. My hope is that it was sufficient, because I think it came back and we re-provided it.
Okay, I'll check.
If it's not sufficient, let us know.
I'll check on a break to see where it's at.
Lawyers, talk into the microphones.
It's bad. I can't hear anything. Thank God for closed captions in this case. That's what I was thinking, Idaho Charlie, but I don't know, because I haven't heard it yet. I only heard it word of mouth from someone. So I'm very eager to get to this point where they're going to talk about the knife. But do you guys think there's any chance that murder weapon was recovered? I don't know.
The last update we had was law enforcement back in 2022 or 2023, that was it Chief Fry that said they haven't recovered the knife at that point?
Yes.
So I don't know. But if they did, I think Anne would say something, because she likes to speak through emotions.
This morning, received the defense's proffer regarding
But then again, no mention of the killer sitting down, right? That was interesting. I thought she would talk about that once I found out about it, I'm like, oh, she never mentioned this at all. So I think there are certain things she's avoiding.
Well, if she talks about it, then so that's a theory that Dateline put out, right? But if she talks about it, then it may look like that her, you know, Bryan looks more guilty because it may seem like it's coming from him and not based on investigative theory, you know?
Yeah. Yeah, you're probably right. Oh, look, a scroll. Hi, Jahara.
And that will be sealed per request, I'm assuming per stipulation. And I want some additional information. What I'd like is by the 23rd, if possible, for the defense to do two things. One, provide me with whatever actual evidence you have that supports
she
those
can
allegations.
When I'm done with the hearing, she can,
rather than
Mallory.
just,
Absolutely.
Allegations. And two, provide for me how it is you believe that what you are offering is admissible. Because it seemed to me much of what you had put in there was fairly, potentially fairly objectionable in terms of admissibility. So I would like to see that. And then I would have the state respond by the 6th, which is 2 weeks. And then I would propose a hearing on the 18th.
So is this about the evidence of the alternate perpetrator? Yes, that's what it is. So hearing on the alternate perpetrator is June 18th. The state's got to respond by June 6th. Interesting.
Your Honor, on June 18th, Ms. Nassau has a conflict in the morning, but we could do an afternoon hearing on that day.
Can we do the 20th? The 19th is a holiday, and the court is closed. I'm just not sure whether it can be done in a half a day or in the afternoon or not, depending upon where we're at. That's my concern.
Your Honor, for me personally, the 20th is a little bit of an issue for personal reasons. If we could avoid that date, if we can't, then I guess we can't.
Well, let's. Can we start by noon on the 18th?
12:30 or 1. I'm in federal court.
Let's do 12:30. Are you handling those issues?
Alternate perpetrator. I'm, yes, very involved.
Let's do 12:30 on the 18th. All right, next I want to go to juror questionnaire discussion. Before I do that, this was that was, as I said, sort of a catch-all category. So I won't ask you if you have questions now because I suspect it will fit into, if you do, a more specific category, and we can address it at that point. But if you have a question or concern about anything we've talked about thus far, now's your chance. All right, juror questionnaires.
Uh-oh. What happened?
I don't know. You pause? Loading. Can somebody get a seat for Jeff Nye? He's stuck in the back. I feel bad for him.
For counsel from either side to be present during that stage, we'll focus on the task at hand.
Okay, very well. Does that accord, Ms. Taylor? Very well.
I would think so, Twisted Stitches. I know, Carrie.
So as I indicated, you'll be given access via
Slightly.
shared drive. You can do two things. One, you could save those over to a copy over to a drive in which you can make edits, or you can print and make hand edits, or you can just keep track by notebook and juror number. If you want to do the printed version, you'll need to bring your own printer and supplies in order to print those off from your war rooms.
I personally wouldn't want a jury
The plan
sequester
will be
because
to take the universe of jurors who are summoned and then scramble them randomly and assign them what we call scramble number, 1 through 10,000. And then we will bring them in to fill out the questionnaires beginning with 1. So that the questionnaires that you receive first will be the jurors most likely to be in the line of fire, so to speak. But, because once we have enough jurors, we'll stop. So that's the plan. Anybody have any concern with that?
Concerns, thank you.
Technically, under the rules, you are entitled to watch the scramble process, which literally involves the jury commissioner hitting a button. I don't know if any of you want to be there for that.
Thank you.
I think
yeah, we
his
do.
parents-
Very well.
No, I was saying I think his
I do want to stress the security and confidentiality of the juror questionnaires, as I'm sure you're aware pursuant to Criminal Rule
I don't
23.
think so.
Those are extraordinarily confidential. The copies that you receive
No.
will be, we'll maintain a copy, obviously, for appellate purposes.
What?
Do you want to pause? Crafty Chris, no, because Jake Loxton is part of the defense team. My opinion is that they brought in Bika Barlow to take his place and seat because she has a specialty as a defense lawyer with DNA and more like biomedical kind of experts in her field from what I took of her CV, because she was actually being consulted and going to be an expert witness. So with my opinion is with Jake Logson's new role, and you know that now that we have the tip coming through with the DNA and all these things that we saw recently, Bika probably fits the best person to kind of take Jake's spot. But I don't think it has to do with that. Now visually, does that like kind of catch your eye? Sure, absolutely it does. I mean, I've even thought that too. I'm like, wow, it's like an all female, and maybe, you know, maybe it softens Brian. I don't know what that looks like to people or the jury. I'd be curious.
Definitely.
The copies you receive will be returned, and the defendants, they're supposed to be essentially attorney's eyes only. I'm fine if you both agree to allow an investigator to see, so that they can be doing, you know,
Oh yeah, Patrick.
online investigation they feel appropriate as you go along. Doing that in terms of the defendant, his access has to be with attorneys present. In other words, you can't have a copy or whatever to go back with him when he's not with you.
That makes sense, but I have one question for the board. In addition to our investigators, we have 3 that are working on the case. We would request our paralegals be allowed to assist us. Just with the magnitude of the task, we'd like to have the assistance of our paralegals in organizing and reviewing.
And likewise, Judge, we would hope to use our administrative assistants in the process, and they are part of our staff.
Sure, and by court and bar rules, you're responsible for their conduct, and so you'll need to make sure they understand the confidentiality of those questionnaires, and it's really your ticket on the line for their behavior. So that's fine. But I do want to stress that confidentiality, because it is part of what I'm giving the jurors on the instructions, is letting them know that there's a very limited number of eyes that will review this, and that the public never will. So. The plan will be to try to process.
Interesting that he made sure to reiterate, as long as the paralegals know the confidentiality, right? Right? Kind of addressing already. Shit's coming out left and right. So you want your paralegals on, no problem. But they better not talk.
And you know, the court being responsible for the jurors, like absolutely, because they're like when they do the live stream, if you've ever watched court process or court, or if it's your first time, they don't show the jury. And it's usually after there's been a verdict that some jurors may come out, but a lot like to remain anonymous.
Yes, definitely.
So I also think from that perspective, not just like the case file, Melissa, like you're saying, but even like their own protection, right?
For sure. Absolutely. And that, but it all comes back around even more so because there is a leak, right? And all of the resources that you just listed, not just for one reason as far as the information, but as far as protecting the jurors.
The first questionnaires, as I said, you'll get them each day and go through them. After 3 or 4 days, we will start to have hearings. Those will be sealed hearings because we'll be going over the questionnaires in detail, in which you folks identify the concerns you have with the questionnaire answers, specifically whether there's a motion or agreement to strike a particular juror before we ever have to bring them in based upon the questionnaire answer. Right? And the idea is to dismiss those who are unlikely to be put on the jury because of either perceived bias, knowledge of the case, or hardship. And so, I think it helps everybody if we are trying to agree to that as much as possible. It's the reason that we are summoning as many people that we are, is so that we can really cut through the chaff and get to the wheat.
Alternate perpetrators.
Any questions about the juror questionnaire process?
Sure.
So the next topic I have is voir dire, more specifically. Traditionally,
August
the way voir
11.
dire works in Idaho is the court first does its voir dire, touching on some essentially statutory kinds of bias or knowledge. And then counsel is given that opportunity. And so much of what would be the court's voir dire, I have incorporated into the questionnaire. So as to
Right,
my
Missy.
role in actively questioning the jurors, potential jurors. I may follow up on some of the answers given on the questionnaires if I feel there's a need to. But otherwise, the time will be yours. What I intend to do, I'll get your input on that, is using a model very similar to the model Judge Boyce and I came up with in the Daybell case, bringing in groups of anywhere from 15 to 20 people at a time, having a general session of questioning by the attorneys, approximately 30 minutes aside of those folks, get through challenges for cause or dismissals for hardship, et cetera, of those folks. And then who's ever left over of that group then would be subject to individual questioning by the attorneys. And so the jurors that are left over will be taken to, for example, the jury room and wait in there. And then we'll bring the jurors in one at a time to answer questions from counsel. The goal is, I'm not going to stop you if you're getting important information that needs to be got to. But the idea is after that more group discussion, the individual voir dire will be more for very sensitive topics.
Right,
but also
Evlas.
for knowledge they have about the case from media or otherwise, because I don't want them to talk about it in front of other jurors. And then other topics that you sense were too sensitive to talk about in front of the others. Hopefully we can get through each of the individual jurors in 10 to 15 minutes apiece, but we'll play that by ear. We'll see.
Question?
Sure.
So the 10 to 16 people in the general session, is that going to be the court's few questions and then each counsel has general questions? And just to make sure I understand, then whoever's left from there, we pull in and then we talk about case specific information, the media items?
Media items, correct.
Okay. And would you envision that during the time we talk about media items, I can also find out their views on capital punishment?
Yeah, it may be that you are able to talk about that with the larger group to a degree. There may be some who appear sensitive to that and prefer to talk about it outside, and we kind of play it by ear. So it's not a subject I'm going to forbid from being discussed in front of the larger group. And you'll have limited time with the individual. So, you need to balance how you're going to use that time.
We may have to see how it plays out, Your Honor, but in my view, talking about the views on capital punishment is fine in a bigger group. My preference would be to be able to get the media items, people that aren't going to make it, to let them go before we do that. I think it would save time to have them gone before we do the capital punishment rules. If we know they're not coming, they're not going to stay because of media coverage and those kind of beliefs and views, it makes more sense to have them go before we start talking about something else. My concern is the amount of time and that the media coverage items might find their way into a discussion of capital punishment.
Well, I will make it clear to the jurors that they're not to discuss anything they may have heard in the media during that general session. And we'll play by ear. If it's not working, we can change it, right? So let's, and this is very similar to the way Judge Boyce had done it. I think it worked well. They got a jury fairly quickly. Now, as much as the attention was in that case, obviously this one seems to have more publicity. But I think that handling it with first going through the general, because we're going to lose people based on hardship, based on, have they made up their mind? Yes, right, kind of stuff. And so we don't even need to talk to them. And then we can get into issues, or they may, simply give a view of capital punishment in that one that it's clear that they're not qualified either one side of the coin or the other. But if you want to deal more, if they're hedging or you're sensing some concerns, you can use that follow-up time in individual sessions to follow up on that rather than trying to do that in the public session. Any questions about that, just in terms of how the question will go? So my intent in terms of public access to the voir dire process is that during the group session, victims and defendant's family will be present. A small number of public seats will be available. And then it will be streamed to a larger room in the courthouse for anyone else in the public that wants to watch. It will not be broadcast outside of that closed circuit. Because then I lose control of the recording in the event that a juror's identity is revealed, and then I get all the internet sleuths out there trying to figure out who everybody is. And I want to protect the juror's privacy as much as possible in that regard. And so this does allow for a public access is the right, but also allows the court to tightly control that process. And then the individual voir dire will be counsel and defendant only. And there'll be no stream.
Potential jurors' faces and names obviously won't be broadcast.
Correct. The faces will not be broadcast, and you are to only use their scramble number as their identity throughout this. So they will never, you will never speak their name, nor will I or the court. They'll only be by that scramble number, and the camera view will not show their faces.
The juror number by which we'll name them, will that be on them, or does this court use paddles so that their numbers can be held up when we?
They'll have a laminated paper, like 8x10 paper that has cardstock laminated that has the number on it. It'll be the scramble number, not their original reporting number.
I'd like to be a juror on a murder case.
Me too.
My goal is to try to get through 4 panels a day, which may not seem like it's much, but I know from the prior trial that they struggled to get 3 a day. So my goal is to try to get 4 a day, but I want to get to at least through 3 panels a day. The plan would be is once we get through the number of jurors we need to sit, including alternates and peremptory challenges, plus a few extra in the event something changes before the time we exercise the peremptory challenges. Once we get that number, let's say that number is 50, that's where we would stop and then go to the peremptory challenges. Does that make sense? Any questions about that?
Just to clarify that I understand it, we'll get enough people that we get 50 that have not been challenged for cause, and then
That has been passed for cause, you're correct. But once you get that, if you will, struck panel, then we will exercise the peremptories. With respect to the number of jurors, prior to Friday, I had intended to use 6 alternates, and after Friday, I intend to use 8 alternates for a total of 20. That's about the maximum that I can fit into the jury box that we intend to use.
I think we're going to get a few switching out of the jurors.
So that number, 20 plus strikes, which would be 12 strikes apiece pursuant to rule.
12 strikes
gets us to,
apiece.
44. And so the plan would be to get 50 to 55 that have passed for cause to bring back for the peremptory challenges in the event that we lose somebody for some reason in between.
No, because it's
questions
just
about that?
pretrial hearings and it's streamed publicly, I would imagine, FOS, but anyone can go in there.
So, and then when we're exercising the challenges, what I do is I give you a time limit geared to the number of peremptories that you have. So here, for example, you have 12 peremptories, give you each 30 minutes to exercise those. And it's a chess clock. So while the paper is with you, your clock is running. And once you hand it to the bailiff, it stops running and the other side starts running. Once you reach your 30 minutes, absent some showing of something happened outside your control, then your peremptories are over. Now, that's usually I give 1 minute per peremptory in the typical trial. I'm giving you far more than that here. It shouldn't take that much time, particularly with the number of people that you have keeping track of everything.
How many of you guys would want to be a
If
juror
you
on a
both
trial
pass
like this?
On a round. Or let's say the defense passes at the end of round 4, and then the state passes at the beginning of round 5. That ends the use of peremptory challenges because you both have said to me, by passing consecutively, there's nobody that you want to strike. So understand that once that rule as you go in. After the panel is selected, the jurors and the alternates, which the alternates won't be determined until deliberations, when by lottery, who's ever left will be determined to be the jurors, and the alternates, those who are drawn by lottery to be an alternate. But that group of jurors, and so the 20, will be taken to another location in the courthouse. I will briefly meet with them, simply to introduce to them the people that will be talking to them, which will include the trial court administrator, the jury commissioner, and Judge Cawthon, who will be acting as it relates to this case as the administrative judge during the trial, to help them understand the process that we will use for juror security, for juror privacy, for reporting, and all of that, to answer any questions they have about that process, so they know where to go to ask questions about the process, and sort of, if you will, onboarding them. counsel won't be at that, nor will I, other than to introduce the people. And then I will leave so that I don't inadvertently hear anything that I shouldn't hear on my own.
I would, Robin, and I know people may have issues with that, but I'm just going to be honest.
I want to stress the importance of.
I don't like when people say that you are sick if you'd want to see something like that. It's not a matter of wanting or getting satisfaction from seeing autopsy photos versus I'm a visual learner. And let's be real, there's a lot of professions where you have to be okay with that. So I don't know why people make it seem like, why would you ever want to see that? Well, I've followed the case from day one, and you could only, so when the medical examiner, when the camera's pointed away as she's going to go through all of the photos, as she's explaining the injuries, she's going to have that pointer, or him, her, but she's going to have that pointer, and she's going to say, now, if you could see this abrasion here, this abrasion is going to indicate that there was a defense wound, and you're going to see this, and you're going to see, whatever it may be, petechia of the eyes here. If I can't see that, I'm not really understanding it. I'm not really absorbing it. So yeah, absolutely. If I had the option to see the photos, I would, not because I would get enjoyment from seeing it versus I will have a better understanding. And I don't like when people shame others, because every medical examiner, every doctor, every, a lot of crimes, homicide, it's not like you have to have this sick, morbid fascination with it versus a complete understanding of what occurred.
Right. And, personally, like, I'm not one that I can watch like any kind of, like torture, gore, like horror films. Like I grew up liking horror films, like the classics, but I was originally going to school for forensic chemistry. I wanted to work in crime scene investigation. And there's something about separating your mind and what your mind's purpose is. Like mine is, I wanted to be able to, through science, be able to maybe help solve cases, bring closure, like be part of that. And like I think there's like it doesn't like take away the horrific nature, but it's like you said, the scientific mindset of what do you get from that? What do you learn from that?
I know. Yeah, you know what I will say though, yeah, Carrie, but I do sympathize a lot with the jurors, because not everyone could handle that, and I don't know how I'd feel like if I didn't have the choice, right? Because I have the choice when I want to see, or if I didn't want to see. I'm sure that there are cases that I really would not want to, depending on what it was, and so it's got to be hard, because it's gonna stick with you. I could tell you all of the ones that I've ever seen have stuck with me. So it does suck.
Yeah. I mean, like even to this day, like one of the first cases I really ever got into is the Black Dahlia, and even seeing
That's so weird that you said that, because one of the first ones that popped in my mind when I said, oh yeah, no, they suck, because I'm trying to think back even to older ones, and Black Dahlia right there. Yep. Even though it wasn't an autopsy, but a crime scene photos, yes. Yeah, you can't unsee it.
No contact with the jurors in any way by you, your staff, your witnesses, anybody affiliated with the case. And so they need to be instructed.
Thank you, FOS.
If you happen to see a juror somewhere else in the courthouse or at the grocery store or at the coffee shop, you're not to even engage in pleasantries. Turn tail and run the other way as fast as you can.
Turn tail and run the other way.
If you have any contact with the juror, you need to report it immediately to myself and to opposing counsel, so we can then make any inquiry that we need to. I issued yesterday an order in this case regarding sort of the rules of the road for those attending the trial, as well as an administrative order that I imagine will be on the court's website here if it's not already, outlining some of that as it relates to outside the courtroom. So my order in this case relates to the courtroom. The order, as I signed as administrative judge, relates to the courthouse at large. Make sure you have reviewed that and make sure your team understand that. There will be portions of the building that will be off limits to the public and to you.
I'm sure, Homer.
So make sure you understand that as well.
Really,
given both of you,
Gidget?
if you were here to look at the facilities, it's important that we know where it is you intend to stay as soon as possible, as well as any witnesses you put up, et cetera, so that to the extent that we ultimately may need to sequester jurors, which once it goes to deliberation, we will have to at a minimum, that we steer you away from whatever series of hotels that we've reserved as potentially available for us to use, that you're not there. So let staff know if you intend to stay at a hotel, if you intend to put witnesses up at a hotel, intend to have staff stay at a hotel. Let us know where that's going to be.
Thank you, Neat. Congrats. Hey, Carolyn
Each of you
Cooper.
assigned a conference room outside the courtroom.
Shay, I've been saying this. I don't know how they would do this without sequestering the jury. I do not know how they could ever do this trial without sequestering the jury.
I think that they could go without it, but one of the things that makes me nervous about, there's pros and cons, right, to sequestering a jury, but it reminds me of, like, I think OJ was sequestered for like many months, and like, do sequesters maybe encourage the jurors, I don't know, to like want to get a verdict done quickly, like, and could that hurt the defendant? Is it, I look at it so many different ways, so I don't know.
I absolutely understand, and I don't disagree with you there, but then I weigh, because I could also say, oh, that is going to be massive exposure for 3 months. You have to have these jurors out in the public and going back home at the end of the day, and it's going to be everywhere.
But even if they are sequestered, I wouldn't imagine that they would give up their cell phones. Like, they would still get to talk with their family.
As far as I understand, they still do get to talk with their family, but it's not, you don't get free. I don't know how it works. I've heard that it works some ways with some, and then I don't know if that's all, though.
Interesting.
Yeah.
And you'll be given a key to it that you may lock each day, that nobody, including janitorial staff, will have access to, where you can keep your papers and files if you'd like, or other materials.
Right, Neat?
And to use to meet with witnesses, et cetera, as we go along. All right, before we turn to the trial itself, any questions about the jury selection process for the jurors?
Okay, next up.
So the trial itself, the plan is to go from Monday through Friday, with the session with the jury beginning at 8:45 each morning and ending at 3:30. Once we hit a sequestered phase, whether that be, for example, in a penalty phase or earlier in the case, should it become necessary, I will likely extend the hours of the trial to fill up the jurors' days. Part of the reason to give some time at the end of the day is so that they can do the errands of life that they need to do. But if we are hosting them, so to speak, we don't have to worry about that. And I'm sure they'd rather have their day taken up moving forward on the case. So that is the general plan. Counsel and the defendant dressed, ready to go at 8:15 each morning, from 8:15 to 8:45. If there are issues to discuss, that's when we will do them before trial starts. As I encouraged you when I first started this morning about this would be a really good time to discuss anything that you've just uncovered that might be an issue in the case. We will likewise have a period at the end of the day from 3:45 to 4:30-ish to similarly address issues that may be coming up the next day or in the near future. At this time, I do not intend to have trial on October 2nd and 3rd. Because of a previous commitment that I have. I talked to you before about potentially being gone on the 14th and 15th. As of now, I've been able to make alternate plans. So for now, you should plan on being here for trial on those days. Holidays that I could spot quickly on the calendar include September 1, October 13, and November 11. So those are holidays for which there would be no court, with the exception that if we are sequestered, we may have trial. And we'll address that as we go, because I can't send jurors home for the holiday, and so we might as well use the time. Any questions about that trial schedule?
Thanks, Pity Mama. Welcome. And have been
Right,
called.
in terms of special needs that you may have for trial.
Oh no,
I'm
crocheting,
assuming
damn it.
there's no need for us to have interpreters for any witnesses.
That's crazy.
And then technology needs, be sure that you make sure whatever technology you intend to use works in the courtroom in which we will be. The best way to do that is to contact Ms. Barrios, the trial court administrator, and reserve a time to come down and try it out. I also suggest that you use on your team somebody that is far more technologically savvy than certainly I would have been in your shoes. Perhaps you are, but it's important to have your own IT kind of person there to deal with any issues that may come up. If you have litigation presentation software and it's not working, you might get a short recess of a few minutes to work it out. But if it's after that, we're just going to move forward and you'll have to figure out something else to use. So it would behoove you to have staff there that can deal with that. Likewise, in the event that something comes up last minute and there's a need to redact some portion of audio or video or other presentation, that you have somebody there that can do so quickly and knows how to do so quickly.
You and me both, girl.
And I would encourage you to plan ahead to have alternate versions of such things so that if there is a concern that's unresolved going into it, you have version A and version B you can use depending upon
August 11th, C. Carter.
Any questions about technology? In terms of what we provide, it will be a overhead, what we call the Elmo device, which is the device where you set a piece of paper down and it projects onto the screen. And then we have a HDMI
Welcome,
link
Sprinkled
for your
Donut.
computer. You present whatever you want to from your computer. That's it. That's our technology. So anything beyond that, you'll have to bring. All right. Let's talk about seating in the courtroom, counsel table, and the trial broadcast. Each side, I think when we toured the courtroom, each side will have two counsel table kind of put together, which should give you, depending on how closely you want to sit together, anywhere from 4 to 5, maybe 6 seats at that table to use how you wish for yourself and your staff, and in the defense's case, the defendant.
Thanks.
As I also indicated, I would provide a small table behind defense because they're not really as close to the bar as the state would be. A table behind you where you can have staff, 2 to 3 staff members.
Thanks, Samantha.
The state will have some room behind the bar, directly behind them for its staff. What I need from you are numbers. Understanding the space that you have in the well. How many seats do you need? Well, how many seats are you requesting and how many seats do you need are two perhaps different issues. But in terms of requesting, this does not include, for example, the victim's family.
Yeah, I'm okay. Thanks, S. Dakota.
Defendant's family, but for
Thank you.
staff. So apart from the 2 or 3 seats behind you, I'm assuming that's enough for you.
Good
For
night,
the state,
Sarah.
Likewise, 3 seats, 4 seats.
Make that work, Judge.
So is he saying this is going to be the actual courtroom?
Mm-hmm. Well, wait.
In terms of reserve seating
Oh, shit.
for
Is that what he
victims,
said?
Tiny.
it will be for those
Do you
statutory
want to
victims
rewind
that
it?
was agreed to by the parties. Likewise, 3 seats do you need, or 2 seats that will have some room behind the bar, directly behind them for its staff. What I need from you are numbers. Understanding the space that you have in the well. How many seats do you need? Well, how many seats are you requesting and how many seats do you need are two perhaps different issues. But in terms of requesting, this does not include, for example, the victim's family or the defendant's family, but for staff. So apart from the 2 or 3 seats behind you, I'm assuming that's enough for you. For the state, likewise, 3 seats, 4 seats.
You'll make that work, Judge.
In terms of reserve seating for the victims, it will be for those statutory victims that was agreed to by the parties. And for the defense's family, it would be those 4 members that were identified in terms of reserve seating.
Yeah, that would take
what
up
I
the
would like to do,
whole
though, is
seating right there.
I suspect that it's
I would
maybe
think
that
they'd use a bigger
everybody won't
courtroom.
be at trial every day.
Yeah.
And so what I would like, excuse me, is for those that have reserved seating, in particular the victims, and I should point out I am going to reserve 2 seats for the 2 surviving roommates who are technically victims of the burglary. I don't know whether they would have any desire to be here. I suspect not, given the way they've been treated in the media. But
Aww.
if they would have seats available. But anybody who has reserved seats, I'm asking that they notify the trial court administrator what their plans are for each week. So if you tell me you're not going to tell the TCA, we'd like to know, for example, we're not going to use 3 of the seats on Tuesday. so that we know, so that we can make those seats available for the lottery system, or it's not technically lottery, it's a first come system on a computerized basis. But if we don't hear from you and you haven't made arrangements, we will assume that you don't intend to be here. So it's important that each week you let the trial court administrator know. She'll give you an email address if you contact her, where you can send an email to tell us whether you'll need all of your seats or not that week, and which days you won't. That goes for both the victim's family and the defendant's family. Right now, the plan is, and this is subject to change, to have a reserved
Thanks,
seating,
Kitty Mama.
I don't want to say reserved seat, a seat selection process by which people can go to a website each day and at a certain time, and it's kind of like buying concert tickets, indicate a desire to have a seat, and the first X number that are available to get through will have a seat. It will be necessary to bring identification to show that you are who you are, or are who you say
Thanks.
you are.
So there's
To
that.
get into the courtroom.
You guys are the best.
Again, that may be subject to change. I think the intent is for Judge Cawthon to have a town hall meeting with media in June.
Welcome,
to
new
determine later,
members.
to go over sort of what that process looks like, so that gets
Thanks.
so the media is aware, and so that then it gets publicized to the general public that would want to be here. My intent at this point is to allow a stream of the trial proceedings controlled by the court to be run on the court's, where if anybody's watching today, where it would be today, on the court's broadcast page. The views will include counsel table, the podium, the witness stand, and the bench. There will be no production of the video, meaning there'll be no close-ups and zoom-ins and zoom-outs and things of that nature. It'll be the static views.
Hey, KV.
Before the court goes further, when we're talking about the reserved seat for families and orders,
Thank you, Jen.
trial, can we request an extra seat for a day for them?
Yeah, we probably be able to accommodate a few days here and there, but seating is going to be very limited, right? And so I don't want to extend that beyond the immediate family as a general rule, but if there's a specific day or two where there are going to be a couple other folks in town, talk to the trial court administrator, and she'll see what you can do.
In addition to that, we have one other person
Yes,
on the team
Carrie.
that would like to have sit with the victim or with Mr. Kohberger's family. It's not somebody who would testify. So if we could have 5 seats, it's somebody who will just assist them. As the media, I try to talk to them a lot.
All right, I don't have a problem with that. I'm assuming the victim witness coordinator will want to be there as well. So,
And Your Honor, because court is
So
where we
parents and 2
have,
sisters.
unlike most cases, we have multiple victims. So we will have multiple victim coordinators to work with separate families. We will coordinate that with Ms. Barrio's office to let her know.
are you talking about one per family?
Hopefully not like that, but we're going to need to split at least. We're going to need to have at least 2 separate groups.
All right, let's try to keep it as limited as we can, just because seats are at a premium. But
Understood. Your Honor, may I also ask the court in regard to the live stream from the witness stand? I believe that we mentioned this at least in passing in our trial brief. The state anticipates that we may have witnesses who, for reasons the court articulated about the other 2 victims, the surviving victims, that public live stream where their images can be captured and played games with in the media world. Is it possible for the video of that live stream when they testify to be shut off and just have the audio? We also may have a small number of law enforcement witnesses who also do covert work, and broadcasting their images publicly would be desirable. We will advise the court. We've asked the agencies to identify anybody in that capacity and to specify the basis, which we'll bring to the court. I just want to give Your Honor a heads up.
Your Honor, this case is very high profile, and we've had people who have expressed reluctance to talk to us and being willing to testify for similar reasons. We did have a chance to speak with the state this morning, and we agreed that what we'd do is take a look at our entire witness list and try to figure out people that might be more sensitive to having their video camera on their face while they testify, and we may approach the court with a stipulation for certain numbers of them.
well, my intent would be with respect to victims, and I've already indicated I think the 2 roommates are victims. There is a compelling interest to protect them, and so just as typically when media is present, they're not permitted to photograph or video victims that may be in the courtroom. If the victim requests it, their face will not be shown during the broadcast. In terms of those that work covert, I've got to see where the parties land on that. If they weren't covert in this case, I'm not sure about that. I'll have to think about that, and you may have to convince me, because I think there is public interest at play here, and so we'll talk about it. And as for anyone else, you're going to have to really convince me because of the public's right and their hesitancy can be overborne with a subpoena, and that's what subpoenas are for. So I'm probably disinclined to do that in general for other witnesses. As you can see, I'm even hesitating with people that may have a line of work that is undercover if they weren't undercover in this case. So other folks who may be shy, probably I'm going to have to weigh heavily the public interest there.
Or I wonder if the same could be accomplished with a room where there could be a feed for certain bits of testimony to a larger group, and it's still a public open courthouse, and live streaming something that gets captured for millions of viewers that lives on for a very long time might be different. And I can work with the state and then give the court a little bit more on that, but off the top of my head, that's what I'm thinking.
It's going to have to be a very compelling reason to do it. So aside from victims, while we are open in the sense that the people in the courtroom, the likelihood is we can't fit everybody in there that wants to be in there. And if I start not broadcasting the testimony, the full testimony of people who would otherwise prefer not to, that's going to fill up, that's going to be a large number quickly. And the best way that we have to ensure that the public is accepting of whatever verdict may be reached in this case is for the public to have the ability to see the evidence.
Amen, Hippler.
So, I'm not saying no, I'm just saying you're going to have to really convince me.
Thank you.
This is why I love Hippler.
All right, any questions about either the seating or broadcasting besides what we talked about?
Not at all, Samantha.
All right, let's move to then opening statements.
They definitely are, Leon,
Let
but
me,
they get that
start with
respect
what you've
shown
probably figured out
as
by now.
victims.
I am not tolerant of argument during opening statement. So if somebody is arguing and there is an objection, it will be sustained. Please don't do it. What I would like you to do is, by about the time that we're meeting again to select jurors, let me know what you estimate the time you need for your opening is. I will then look at that request and give you a time allotment based on consideration of that request. Each side will be given the same amount of time, and then I will hold you to it. In other words, if you tell me it's going to take an hour, I'm not going to tell you you only have 30 minutes, right? But if you tell me you want 5 hours, I might have some questions about that. But if you tell me you need an hour and I give both sides an hour, about an hour, you're going to hear me say, counsel, you've got 5 minutes left. Use of exhibits or potential exhibits during opening statement. Because exhibits are not pre-admitted, even if stipulated to, there has to be an agreement to show the exhibit during the opening. Hopefully you both work together knowing what is coming in and isn't coming in, particularly where there's an agreement that something's coming in, other than spite, there's no good reason to not agree to it because the shoe will be on the other foot, so to speak, down the road. Courteous typically pays off with reciprocal courtesy. So work together on that. But technically, if it's not admitted, which nothing is by the time of opening, and there's an objection to using it, I would likely sustain it. For that reason, it's important that you, if you're going to use, for example, like a PowerPoint or something like that, that you share that with the other side at least 72 hours in advance so that they have a chance to review it and then work out any concerns they have and lodge any objections that can't be worked out with me, 48 hours in advance, so that I can then look at it and make a determination. If I haven't given you a ruling by that time and you're coming into openings without yet having a ruling, I suggest you have more than one version ready to go. One that is anticipates the objection being overruled and one that anticipates it being sustained. Let me reiterate again, please do not argue during opening statements or in
Right, Harlot?
as well. Make a request at the beginning of your opening to enter the well and it will be granted. However, an invitation and permission to be in the well is not permission to invade the personal space of jurors. So understand that and stay a few feet back, at least from the bar of the jury well. If you are going to use...
I see all of your guys' concerns as far as hiding witnesses, and I get it. But honestly, I think Judge Hippler is making the right decision here. And trust me, I want to see. I am a big advocate for being able to see. Again, I'm a visual learner. So I cannot read testimony. You can't, even if you give me black and white, this is what was said. The infliction, the emotion, the way that you are going to communicate it on the stand can change. I could take, I was scared, right? Take that one sentence. Shay can say I was scared one way. I could say I was scared another way. And you could take away the way that we expressed I was scared two completely different ways. So I'm a big advocate for being able to see those witnesses, especially Dylan and Bethany up on that stand. But with that being said, like I want to, I totally understand why Judge Hippler, he, just like he said, the way they've been treated, okay? Yes, they're witnesses, but they're victims. And only for those two, that doesn't mean we're not going to hear it. We're going to hear it, but you're not going to have the camera recording their faces live streamed for them to get torn to bits. And I have to respect his decision. I don't like it, but I have to respect it. And I think he's making the right decision when it comes to the two of them. Everyone else, that's going to be an issue. And that does get in the way of the public's right. And the more and more people that you bump off camera, the more and more the public's going to want to get in this courtroom. And already, yeah, he said, if they ask for it. I think he's making the right decision. What do you think, Shay?
I agree. I think that it also it may. I know that they probably will have a lot of anxiety testifying. I could only imagine. I probably would. I don't know. But say they get the option and they decide to turn the camera off. What if that calms their nerves and makes their testimony more clear for both sides? So I could see that like being a benefit to them as an option, and also maybe how that testimony comes in. But I'm totally with Judge Hippler on the aspect of certain people that in law enforcement or others that you may not want to like show their face or have something be private. I mean, I just believe unless they are an agent that is undercover and it could jeopardize their lives or their families, like why would they not be, shown?
Right.
And I don't
And
know if this is the kind of case that would have that. I would see that in like a bigger RICO or some kind
right.
of drug DEA case.
Well, and again, okay, so we have, as Dakota says, I don't agree. I think they would want to clear their names and not hide regardless. Squeaky Bill says they should offer them the option to wear a mask to help mask their identities. I don't know if you're talking about in regards to you can't really. It's not just about the physical identity. It's their name and it's their, being noted as whatever their job title is. But as far as Dylan and Bethany, no one said that they're not wanting to. They have nothing that, let me be clear, they have nothing to clear their names about. What, public speculation? And I say that even with myself having questions. But the truth is, they don't need to get up there and clear their name. They're not on trial. You know what I'm saying? Like, and I get that we want answers, we want clarity, and we may feel that way. But at the end of the day, they're not getting up on that stand to clear anything except to tell their story and their experience and what they witnessed. It's as simple as that. And so they're still getting up there. Neither, as far as we know at this point, has asked not to go on camera.
Mm-hmm.
I know you are, Dakota. Neither of them have asked to go on. They may turn around and say, no, I want to go up and I want to make sure I'm standing on my word because the whole world thinks I had involvement. Maybe they do. I don't know. But we'll still be able to hear it. It's just not going to be live streaming their face if they request it.
And to add to that, Melissa, I think the most important part, like I wouldn't put a mask on them even if they were on camera, because the jurors, the triers of the fact need to be able to see these witnesses, and they will. They will see them in the courtroom. That doesn't mean we get to, hey, we never even got to see Lori Daybell's trial, remember? Like her one in Idaho. So that was all audio. Like we never even seen Delphi's, guys. And and I think that if you have the audio, I think that's acceptable.
Yeah.
But like I think the jurors are most important, getting to see them. And also maybe we should kind of think about, for the ones that were at that 911 call, or close family members in this, or whoever may be testifying, even first responders, this could be triggering maybe some PTSD, a traumatic event for them, and they're going through a lot while they're testifying. You know, it is, I can only imagine like how much your body would be going through and your responses through that, you know?
The first one was Carrie. Lori Daybell's first trial regarding her children was the audio only, not this second trial regarding
Mhm.
Charles. And so you can't not call them FOS. You can't so, and I understand everyone's concerns. I'm not saying they're not valid. I would like to see them too up there. Again, it makes a big difference, but at the end of the day, it's really all we're entitled to is that public transparency, is not seeing her test just regarding these two victims that are witnesses. Both are true at the same time. Is the transparency not there? The only thing that matters as far as that is the jurors get to see them, and anybody in the courtroom does. And so is you have to ask yourself, is that just because that's what we want? We want to see the facial expressions, we want to see the demeanor, but we're gonna hear it. It's probably going to be zoomed up to the clock in the middle of the courtroom or something like that. It's just not, and this happens all the time. But you can't just say, well, we're not going to call them now. Absolutely, they're critical. They're critical in this case, but they're also victims in this case. So I think he's making the right decision. Again, even if I don't like it, I think he's making the right decision.
And also, we've seen sometimes where you haven't been able to see the witnesses, whatever, whether it's witness specific or trial specific, they'll have sketch artists in there. So I don't know if that's an option, like that maybe somebody will ask. I don't know if it's really a necessity, but just kind of throwing that out there too.
Right.
A PowerPoint or some other presentation, you need to choose at the beginning of your presentation whether you want the lights on or off, and they will remain that way throughout your opening rather than turning them on and off again. So I suggest you do a dry run based on what the light looks like at that time to see what that looks like, to see if you want it on or off. Any questions about openings? All right, next I have witnesses. Before we do that, let's take a break, take 10 minutes, and I'll be back, all right?
All right.
Experts and some potential.
Oh,
Just
All right.
I agree. Curious, Christine. Oh, come on.
during the trial. I certainly will listen to them, but that is the gist, is that they will provide, since the gist is that.
Well, actually, okay. So, and that's the thing, as Dakota girl, we don't automatically have the right to see. Like, it could be closed. Like, Judge Hippler could have said, no, you know what? I don't even want, like, that's not the way it works. Like, the public has the right, like, live streaming is more recent. Like, that's not always the case. It's, you got to get in there, hike out, sleep outside, right? And you have the right to be in the courtroom. Live streaming is more of a recent thing. And so anybody in that courtroom, if you want to go old school and you want to go and you want to see the witnesses on the stand, go ahead. You could go. No one's stopping you from going, and I'm not saying you, I'm just generally speaking, like a matter of just general you. You could go, and the jurors, the fact finders, get to see it. But as far as us sitting here wanting to see it, like, it's two witnesses that simply we're going to hear, not actually see. Guess what? They could turn around and say, you know what? I want the cameras off and the audio's off. Do you guys understand they could do that?
Mm-hmm.
We even saw that in Leilani's case. Like, we could have the whole thing just blank.
I think that was probably one of the biggest downfalls of Delphi, that's left a lot of people, whoever, what side of they're on, still feeling the way they do because there was not even audio access.
Right.
Because then you're going off of the interpretation of other reporters. At least we
Which
will
I
get to
hate.
hear it.
Right. Which
Yeah.
So out of all of the options that we've had, I do not think the full access that we have. And hey, with these two witnesses that happen to be victims also, I'm going to, if they ask, only if they ask, I'm going to respect that. We're still going to hear, we're still going to see. And if it's that critical to you, the courtroom is open to the public if you could manage to get a seat in time. So we don't have that right though. Like, not like all of a sudden our right to transparency isn't just ripped because televised they're turning the camera for these two witnesses. You see what I'm saying? It's not about what we prefer. That doesn't interfere with our rights.
Right. I think that if they're kind of getting ahead of this option, I don't think it's as bad as we think, honestly.
No, I'm thankful. I fully anticipated that they may just turn all devices off.
And guys, I like okay, so I made like my own custom feed in Reddit just for like the Idaho case. I have them for different cases. And if I like every day I go in there, like if I look, and right now the hot topic being alternate suspects, do you guys know who still is being talked about as alternate suspects?
Jack?
Bethany and Dylan. And Jack.
Okay, yeah.
Bethany and Dylan the most. Everybody still talks about that. So could you imagine, like, they're going in there to for their testimony of what they witnessed and experienced, and it's the justice for their four friends' lives, and they're still being accused of their case, but yet they're not the ones that are in Bryan's seat. They've been investigated.
Mm-hmm. Well, and Missy, depending on when it is, I'd like to go to Rex's trial. Now, I can't.
I hope you do. Oh, I hope you do.
Shay, if I could work it out with work, I could work out a day or two, but there's a lot of victims in his case. And so obviously I work, and so I can't just, oh yeah, no, I'm going to take off for like 2 months. I got, but I would like to go for a few days, and I intend to. And so I hope it just works out. Yeah, they could be cross-examined. What?
I mean, I hear you, Harlot, but I don't think that even if like they have like a media side pool area, they may have like an overflow room where people can hang out, but not all media people are going to get in there. I mean, right now I think they're on like a lottery pool system on the Karen Reed trial, and it gets picked each week of who gets to go in there. I don't know how they'll handle the media on this, but even for like everyday people, with the way our world's grown, I mean, you can't put the whole population in the courtroom. So we've been blessed to get it televised.
Right. Well, and nothing about Dakota Girl. No one else out of this time is going to have the option. Like we just heard him explain that. He said you would have to really convince me regarding anybody else having that courtesy. And it is a courtesy at their request, but it only applies for Bethany and Dylan because they are victims. They were in the house as a murderer came in and slaughtered 4 out of the 6 of them. You know what I mean? Like, they have that courtesy. They are victims, but he has to call it the victim of the burglary part, right?
Mm-hmm.
And so nobody else gets that courtesy as of now.
Now, if they get the 2 seats in the courtroom reserved for them, and they show the audience in camera,
that's
like
their job. Sorry
then
to interrupt you, but I don't know how that's comparable. FOS, I love you, but I don't know how you could even compare. That's their job. That's their choices to go into work. They chose that field. They know what they're getting into. Not the same at all as the victim in that situation. We cannot, like, it is not, nobody's saying you.
They're not civilian witnesses.
Right. No, but this is the part I'm going to get frustrated at. Nobody's saying you can't go and see Dylan and Bethany up on that stand. Go. But this is the live streaming feed. We're not entitled to that on the live streaming feed. It's the judge's rules, and we should be appreciative, in my opinion, because back in the day, if whoever followed this from day one, we did not expect to even have cameras, okay? So I'm appreciative just step one of that. And if the most I have to deal with, and again, I want to see them up on that stand because I could learn a lot from even the pause in maybe how they may answer something. Well, that pause, I'm not going to be able to see what their facial expression is, right? And that can make a big difference to me, or their demeanor, or their fidgeting. I don't know. But when you look at it in the sense of, okay, they are victims, they are getting completely dragged for years in mainstream media. The least I could do if they ask is to turn the camera to the clock. And if it matters so much to you, go to the courtroom, but you can't sit there and say, well, you're taking away my public right, while at the same time not getting your ass up and going to the courtroom if it meant so much to you. Do you see what I'm saying? Sorry, but like, that's the truth. I can't sit here and bitch. That's like me sitting here and bitching and saying, well, I want to eat McDonald's and I want to lose weight at the same time. What? You know, like, it's my choice to go and eat that McDonald's, but I can't expect that weight loss if I'm just going to continue that same habit. It's my choice. I'm not going to just lose the weight sitting here munching on Big Macs. I think he made the right choice, even though I don't want it to be that choice. I think he made the right choice.
Yeah. I think
such an affidavit each, as they
yeah, Dakota Girl. I think a lot of the federal stuff isn't televised. So if that was
Yeah.
she was asking, yeah. But this is like state by state, you know, they can make the decisions judge by judge.
They are the victims of the burglary, FOS. They were victims because they were in that house. And I feel like that's pretty clear though, right? What makes them different? They were in the house. Dylan crossed paths. She saw him. They were in the house. And I feel like, I know we get all like a bit desensitized to this, okay? But if you were in the house where your family got brutally murdered, you were in that house. You're the sole survivor now. Would we really be asking what's the difference between you and a family member who came the next day after the fact? There's a huge fucking difference. And I feel like we need to step out of the desensitization mode a little bit and apply it to another situation. Because maybe just with this case, because it's so long and we all want the answer so bad, we're not seeing it clearly. This has got to be insane for these witnesses, specifically Dylan and Bethany. And I can acknowledge that while acknowledging, hey, I still have a lot of questions. I do. But just for a second, think there's nothing shady to it. And you're going to get all the answers. Now, are you going to feel a little sympathetic that Dylan literally made eye contact with the guy who just slaughtered her 4 friends, came that fucking close to it happening to her, and having to get up in that courtroom knowing the whole world is fucking against her and having a camera right in her fucking face? Yeah, okay. So if it takes just tilting that camera to the left and everyone still in that courtroom is going to have eyes on her, the fact finders are going to have eyes on her, and we could still hear, I think that's fair enough. I think so, Miriam. I did not expect any cameras to be televised. So I'm thankful.
Well,
we don't
yeah,
have to. Like, we're not entitled to that. I think people need to understand that. We're not entitled to that. You're entitled to get your ass into the courtroom if you want to see due process.
yeah, and I think to what Scarlett's saying, like, you know, not only that, but just to think that like whatever like they saw or heard, like it was actually the murders of their roommates and their friends.
Right. What makes a
And-
difference? Sorry.
No, you're fine. I sympathize and I understand. I want to see it too, but I think that if given what we have experienced in following this case from early on and still seeing the rhetoric, like I think that's a good call. I don't think that law enforcement, like I said, or like non-civilian witnesses shouldn't be on camera unless they are in a position that their job and what they serve and do could put them at risk, and I don't think that this is that type of case.
No.
But I could be wrong. There, people could be transferred, but you just never know.
Well, and I get that FOS respectfully, of course, but it never works like that, right? It's never just a black and white. Well, if there's camera, there's camera. I honestly, I think that Judge Hippler is kind of doing that. Hey, I'm giving you the fixed camera feed. There's not going to be any zooming up. There's not going to be any of this. Just with where's the line drawn when you're actually part of it. Just like Shay said, the difference between these two witnesses is what they are testifying to is the literal murders. The sounds that they heard are the horrifying sounds of their roommates being murdered. That's the difference between people who may, as their job, come in after the fact and not saying that it doesn't absolutely take an impact on them. 100%.
Oh, it does.
100%,
Right.
but it's not the same. Not the same.
They definitely, from what we understood, when early reports, remember when they were getting ready to go on like Thanksgiving and they were interviewing the chief, like they had already were getting counseling and assistance and support for first responders that arrived at 1122 and even maybe some of their family or whatever that may be. I mean, there was like support for the university and everybody. It impacted them greatly.
Right. 100. That absolutely did. There's a lot of victims. I will say that, like victims of different circumstances, but I think the only ones who should have that courtesy, as like Judge Hippler said, the two victims that were the victims of the actual crime he was charged with.
Yeah, I mean, I remember going back and even watching the testimony of some of Ted Bundy's surviving victims. And as heroic as they are to get on the stand and watch it, like my heart breaks for them.
Yeah.
And there wasn't even the social media days to think of what people could have been saying about then that fantasized or had some kind of affinity towards Ted Bundy and they thought he was innocent or whatever weird shit they were into.
Right. Well, and that's absolutely right, Harlot. I'm just kind of on my rant as far as like you saw him, right? You like crossed paths, whether or not they had eye contact. Yep, that's my personal belief. But either way, she saw him in the path of travel while this was going on, right? We could all agree on that because we know that to be true.
The privilege is the cameras, everybody.
Yes, thank you. God, that could have just summed it up so much quicker than my whole hour rant, Shay. The cameras are a privilege. We do not have that automatic right. You do have the right, though. Your public right, is to go to the court.
Yeah.
Cameras are a privilege. Yes, thank you, Shay. That was so much easier.
No, it's fine. I get it. I mean, people probably think back, have questions, but yes, Missy's Angels, I remember that, and that is so sad.
Well,
so sad.
Here, I would rebuttal what you're saying with this Esther Dakota girl. Do you have any evidence that corresponds to that? Does it correlate? Do you have any? I could sit here and say, hey, well, it's also being stated that Dylan ordered DoorDash too. Do I have anything to back that up? I know that there has been a lot of things stated. Have we seen any actual evidence to support that? And if the answer is no, it's just been a consistent theory that's gone around. Is the court supposed to base that? The court knows. And if that was, do you not think Anne would be on top of that in a second? We can't sit here and say, well, these have been theories on what, YouTube? It doesn't work.
No, but I think I understand too. I think what she's saying is that say they heard all that and they were up doing stuff, okay? Like, I think we need to think about, remember when we were going through like the excited utterances and like discovering, it's more of this cognizant dissonance that like you don't go to bed at night thinking somebody's breaking into your house murdering people, it's the after effect, us now that have that information and people that like view it and they're like the gap of time and then this and then that. Yeah, we have those questions now, but in their mindset, did they really think that's what was happening? All right,
Right.
you want to go for it? Sorry, I don't mean to keep going.
Oh, are you kidding? I went on my rants. Hi,
But
J Rose.
I do like the discussion because I think we all have questions. I do. I really do think we have questions about the time frames, and we want to know more about these surviving
Yes.
victims. And I think that it's that tough of like your want and need for knowledge, and versus like what is the path for justice for the victims, and also ensuring that the defendant gets a fair trial.
Right. I think, Mr. I'm so ready. I think I feel like it's so easy to sit here and say, why didn't she ask? Because sometimes, you know what that sixth sense is, right? That sixth sense. And so you have to remember the lead up to why Dylan got out of her bed the third time. And now she opened that door and she already admitted she was in a frozen shock phase. Why didn't she? Did you see the text messages? She was clearly intoxicated. Okay, so that's a factor. But it doesn't surprise me that it took a second for her to even process, oh, there's someone walking by, head to toe covered up. Okay, while I'm sure her brain was on a lag almost. So by the time she may have even said something, he was already out. He was already walking out in that direction.
I could tell a story. Sorry, this may be helpful, and it was like more me coming to after. But so I had roommates. I had a house with, and we were some of them were underage. Some of us were not. Some of us had stuff that's not legal in Texas that looks like lettuce, kind of. And when I came home, I didn't see any of my roommates' cars in the driveway. It was just me, and the front door was open, and I could see from the front door to the back door that my back door was open. Okay.
Hi, Keith.
Instead of calling 911 immediately, I get in my car and I try to get a hold of my roommates because I'm also scared to call 911 because what if this was just a mistake and like I don't want to get one of us arrested? Like I was thinking of things like that and it sounds so silly, but like my first instinct wasn't calling 911 yet. I was also considering that and I was thinking, with Dylan, they don't really know what's going on, but they also have had like 911 calls. Could they be thinking like one of them could be getting in trouble for having a little, schmott or some alcohol in their room and they're not supposed to? Like, I thought like that back then. I could see that happening. I don't know. Maybe because that's my experience.
Mm-hmm. Well, I know you're fine, FOS. I just because I say it like the way I say it, which is always pretty harsh, that's just how I speak, and I don't take it as disrespect. And let me be clear, as much as I just went on this rant, I have said from day one, I want to see Dylan up on that stand and I want to physically see her. I've been saying that since day one. Trust me, I am upset, but I can, like, both things can be true at the same time. I can be like, well, what the hell? I want that transparency. I want to see her, but guess what? That's a lot of I. And we have to accept that it's not about me. It's not about you. And yes, transparency, absolutely. But that I'll circle back around to, if I cared about transparency so much, nothing is stopping me from getting into that courtroom other than a limited capacity. But I have that option. And so I can't sit here and say, well, I don't want to do what it takes to get in there for the transparency. I want the transparency in the comfort of my own home. Come here, let me see every tear, every shake, every quiver of the lip of the witness on the stand. We gotta take ourselves out of this a little bit. You have that transparency, but is it going to be recorded? The same argument Ann just made. Is it going to be recorded? I understand everyone in the courtroom is going to see this testimony, but documented forever in time for everyone to play it back, zoom in. Judge Hippler knows this. Have it zoomed in and have Dylan's testimony played over and over and over and over and over again. Because it's not just in this moment. It's going to be used to create more conspiracies. That's not, oh, I just want transparency. I'm not saying that anyone in here would do that. I'm just saying that's the reality of what we're dealing with. So Judge Hippler, his focus is on, yes, giving the public their right to that transparency, but also making sure he's protecting the victims from being victimized even further. And so I think he's making the right call. Again, I can't say it enough. I don't have to like it, but he's still making the right call.
Mm-hmm. And I know this is the defendant's trial, but remember how whenever we got to this point with the cameras where they were like, "You're zooming in on Bryan," and blah blah blah. Well,
Yep.
if the judge and maybe the prosecution team or whoever, maybe they're thinking ahead of that. Like, I know it's not about them, but their testimony does matter. They are victims of the robbery, and also, I don't know. I guess it's like it's okay to be an outrage for the defendant, but like, about the camera thing, but is there no sympathy for the victims? Not saying any of us feel that way. I'm just thinking it through and talking it out.
Well, yeah. And I did just say that as Dakota Girl. I literally just said two things can be true at the same time, right? I'm not happy. I want to see Dylan up on that stand. I want to see her facial expressions. I want to see how she says something, not just that she's saying. I want to see how she says it. I want to see the way her eyes move, the way her lips. I want to see it all. And I can acknowledge the judge made the right decision because it's not about me. It's not about what I want.
Right.
The fact finders are the only things that matter in this courtroom, the jury. And then you have the right to get your ass up and go in if you want.
And just to address King Scarlet, I laugh because it's funny. I get what you're saying. Yet, quote unquote, whether you call them conspiracy channels or maybe just very off level thinking of some of the stuff that's steers from the facts, they were spinning off of this for 2.5 years with little information. So yeah, I could imagine this will fuel the fire.
Yes.
They come to testify. Any concern with that?
Not with the wording at the moment. A question of clarification, though. If the case should reach a phase 2, does this admonition
I'm running
apply
to the
those
restroom, Shay.
witnesses for phase 2?
Go for it.
So a witness who is only a phase 2 witness
Only a phase 2.
and they attend phase 1. Is that what you're asking?
If they watch or attend any part of phase 1.
Well, the problem with that is that phase 1 is also part of the state's phase 2 evidence, as is the defense's, right?
And I think that would support the need for them to be able to know it if the state's going to
Hold
rely
on.
things that
Are you talking about experts?
Before I run to the
experts
restroom.
and possibly lay people. too.
Pause.
Oh, explain to me why lay people should-
Pause. Okay. Before I run to the restroom. Did Mila request it? Number one. Number two, was the media attention a concern prior to Wade's trial? Or did the media attention come during and after Wade's trial? That is what differs from Idaho. Well, there's a lot of things that differ from Idaho from Wade. But was there scrutinizing and accusations and conspiracies of Mila prior to ever even entering trial? No.
Should be excluded from it.
I don't think they should be excluded.
So you think they should not be permitted to watch the trial?
I think I've got some double negatives going on. I think that if we get to a phase 2, I don't think that those witnesses have to be excluded from paying attention to phase 1. I think the protection for phase 1 is separate than phase 2 because of the rules of evidence that apply to any phase 2, the lack of them that apply to phase 2, and because the state's going to rely on what was in phase 1. So yes, experts and some potential lay witnesses as well.
Mr. Thompson or whoever wants to address this?
Our initial inclination is to leave that to the court's discretion. I think the whole purpose is to avoid prospective witnesses altering their testimony in some fashion based on what they've seen going on in court. That's the danger. I don't know why phase 2 witnesses should be treated any differently than phase 1 witnesses.
Well, what I'm going to do is, I'll give you a chance to each submit something within 7 days in writing on that, and I'll look at it so that you can give me any authority that you might come across related to that issue. Give me a chance to think about it further, and for the two of you to perhaps talk to see if you can understand specifically who you might be thinking of to see if the state has a problem with that. Counsel who calls a witness unless it's clearly an adverse witness, in which case opposing counsel that they have not admonished that witness. But otherwise, counsel is responsible for ensuring witnesses are aware of orders in limine, otherwise clearly off testimony that is off limits. Make sure they understand, the Rule 615 requirements and the fact that they're going to have to sign an affidavit subject to the penalties of perjury that they have not watched this stuff. You make them aware. While we were talking about the jury, I failed to give you the juror affirmation that will have to be signed by the jurors each day. Let me give you a copy of that along the same lines.
Whoa. That was loud.
So that is an affidavit each juror will fill out daily, indicating that they have not violated the instruction or otherwise been exposed to testimony or information about.
Uh-oh. It's thinking. Oh, we got the swirl. No.
Outside of
There
the
it
trial
goes.
itself. If I exclude evidence and you need to make an offer of proof,
What's it doing?
It wasn't me.
No.
Is it me?
No, it's done. No, it's long crime. It's done it twice now. It's not you because I've been able to talk.
opportunity to do that generally is
Thanks
when the
for
jury,
his
when
Christine.
we're not working with the jury, such as the morning session or the afternoon session, so that you can make that record
I
as
love
best
you
as
all.
possible.
Thank you for the debates.
And so
Did you see my comment?
No, what was
that
it?
can be done typically.
Mark
this is
say from the victim witness televised rant. Love a good MJ Passion speech.
Sorry, I'm not trying to be a bitch. I just speak. That's how I speak, you guys. That's just how I speak. But
Oh, I love it.
I appreciate all of the opinions. I do. And I don't disagree with it, but like I understand. Like and I think it was his comment before he even got into it that made me understand it more. Look at what the media did. Just for a second, think they're apps like put everything else aside and think there really is nothing more to it. And they had no idea, and everything is just how it seems.
Yeah.
That's gotta be brutal. Oh my God, you're not blocked, FOS. Dude, you have to do much worse than just disagree with me to get blocked here, okay? You have to do far worse to get blocked.
And I agree, Samantha.
Yeah. Okay, here we go.
And I think that's one thing, Melissa, we've never been afraid to talk both sides, even if we may feel indifferent. Like, I think it's good to learn from others.
I'll kind of always tend to take the opposition. Like, even if I start originally agreeing with one side, if you start kind of going with that side, I'm going to just debate the other side because we should always debate both sides.
Yeah. Well, you understand where somebody's coming from, perspective matters, because not everyone's just like you. You got to think about the jury pool.
Yeah.
What are things that they would think?
Exactly. Yeah, just like it's 10 different people right in here, 12 different people chatting away with different opinions, that it's going to be a jury of 12 peers.
Mm-hmm.
Exactly, Callie.
oral reference to what the witness would have testified or what the evidence would have shown had it been admitted. Okay, let me. I think the rules are pretty clear, but some judges may have more leeway than others about objections. Let me explain to you what my expectations are regarding objections. So objections to questions or exhibits should be stated simply and without argument. It should not be a speaking objection. So for example, an objection, proper objection might be, for example, objection hearsay. Objection to
Oh, I
foundation
hate
requires a
that.
little more. As you're probably aware, there's case law that is an insufficient objection. You have to identify what is missing from the foundation as part of your objection. If you think that doing so would put information in front of the jury that you're not certain I'm going to allow, please ask to approach. I tend to be a rather quick on rulings, on objections.
I like
tend to
speaking objections, or
testimony
at least say what it is.
Yeah.
And I also think that speaking objections, if you're just doing, say, objection hearsay, like that I think it's good for the jury, because I would think if I'm a juror and all these like side quests are going on, I'd feel like I'm left out of something, you know?
Exactly.
objection overruled, sustained immediately, without even giving you much of a chance to express your concern greater, because like potential issue is and whether or not it's an issue. That's it. If you think your ox has been gored and you need to address the issue more, either to have a record or in order to.
I love you just the way you are.
What is going on with this thing?
Dude, it's not me.
Do you want to see what our timestamp is and maybe we try to reload it? Like maybe it just it's like kind of stuck with whatever's on this page is kind of, you know what I mean?
Mm-hmm.
Needs to be cached. I don't know. Sometimes that's like the miracle trick, even though probably what I'm saying like isn't even a thing.
Mm-hmm.
Oh my lord.
Express your concern greater, because like
There we go.
potential issue is and whether or not it's an issue. That's it. If you think your ox has been gored and you need to address the issue more, either to have a record or in order to perhaps convince me that I'm maybe looking at it differently than what you anticipated or than I should, please just ask to approach, and then we can have a discussion.
Good night, Dakota girl.
If you need to make a further record for any reason on an objection or in response to an objection, simply ask to approach, and we will have that discussion. I'm sure by the end of the trial, we'll have to replace the carpet from the trail leading from counsel to the bench, but that's fine. As I've shown you before, the court reporter will have a device. There will be a physical barrier that blocks most of the view of the jury from what we're talking about at the bench. That's rolled out so that they can't see, and we can have discussions here at the bench about that, whatever the issue may be. I have found in doing this for far longer than I care to remember that when I send the jury away to hear argument on an objection, what might take 3 minutes to have the argument on takes 12 to 15 minutes to get the jury back again. And then we lose a lot of time throughout the day that way. And so my preference is as much as possible to have those discussions here at the bench. Now, if it's a very significant issue that requires much more leg room, so to speak, to talk about it, then I will chase them out of the room, but I prefer not to handle the more routine stuff. One of the things about, I've had counsel before who confuse the idea of the need to make a record with the need to get my ruling and then offer a rebuttal to it.
Ooh.
That's not making a record, that is making a rebuttal. And at least until it goes over to State Street, I get the last word. So I don't generally afford that.
I get the last
So if
word.
after I rule and you tell me you need to make a record, it truly needs to be a record on something that for some reason you were unable to make when you had the opportunity to do so, and not simply to see what my ruling is and then try to pick it apart.
God, I like that.
What I started with is I don't like surprises. If you anticipate an objection or you anticipate objecting to testimony you certainly know is coming, let's talk about testimony, whether that's grand jury testimony.
That's right. I didn't do
transcribed
anything.
Witness interviews.
That's right, Hippler.
Whatever it might be, please get that to me before the witness hits the stand, and preferably towards the start of the trial, so that I have that available so I can have read it before the witness testifies, so that when you then ask to either impeach or to refresh recollection, whatever it might be, I will have read that testimony. Don't be mistaken in your belief that I have all that testimony. If it, for example, happened with Judge, I don't necessarily have all those transcripts, so get them to me.
I actually think it's really important to watch the pretrial stuff. I'm sorry. I was saying, I think it's so important to watch the pretrial stuff, because I notice sometimes, I'm a Twitter person. I like to go in there and just like read stuff, don't really post as much. But I notice people who like get on to like a case and wanting to watch the trial, and maybe they haven't followed it, or any of the court docs or any of the pretrial stuff. They have like all these questions, and I'm like, just go watch the pretrial. Like all of how and why the court is running the way it is has been discussed. So I'm glad we're getting
People
to kind of
don't
see
want
this.
to take the time to do that, though, Shay. They want just the headline clickbait, right? Oh, Kohberger this or that. And it's like all, but they don't want to take the time to go through the documents or go through the time for the pretrial motions because it's not as sensationalistic.
And I think it also depends on how you're watching it. Some people may be wanting to watch it from a juror's perspective where they didn't want to follow it all. I get that. But
I get that, yeah.
but knowing like why the courtroom's running a certain way, if you've seen it run a different way, this is helpful.
How itchy do you think Santa's beard is?
I don't know. I don't know. They did a really cute prosecution attorney appreciation post in the University of Idaho group. I don't know if you saw it, but it's the one where he's in a band, guys. He's a really cool guy. So I thought it was cute. They did it for Santa this week.
I imagine just wanting to take like a tail comb and just scratch in that. Like that's a thick beard.
Oh yeah. I wonder if he knows like everyone calls him Santa.
Oh, for sure he does. Ho ho ho. Okay. Yeah, he for sure.
Your Honor, if they've been supplied with exhibits and the purpose was just for that, will that be enough for the court, or should I have an extra transcript at the start of the day if I think I need it?
It said he's like in 3
So let me know as
minutes.
far as advance as possible, and I will have staff look for that.
Santa rocks.
Otherwise, it's probably safest just to provide me an actual copy of it.
Oh, yay, Tracy. We're happy to have you here.
While I'm thinking of it, because I'm in my mind envisioning the materials from grand jury that we have here, the state did file a motion to get back its exhibits for use at trial. I assume there's no objection to that.
No objections.
All right. Mr. Thompson, if you may make arrangements with staff here to get those while you're here, okay?
That is good that they're addressing this, because I've seen in other cases where they don't have the grand jury testimony ready when they're going to impeach.
Right.
And they end up having to call a sidebar, and then the judge has to call a recess. And if they have to print out binders, like good to get ahead of this so this trial keeps running smoothly. I think less gaps also makes testimony more impactful, as well as keeps the attorneys like on their they're not having to like pause when they're on a roll. Like, so say if Anne's like in a really good cross-examination, she's got to pause to go like print out transcripts and stuff. It kind of like, I don't know, just stops the vibe. Like, I think it's good that they're doing this.
I think it's wonderful. And I really appreciate Hippler wanting to get all of this out of the way. And he's also being considerate of the jury, not wanting to have to dismiss the jury left and right every time you guys need to have a sidebar. I really do appreciate that.
Yeah, I agree. And if they're sequestered, they'll definitely appreciate it.
For sure.
Your Honor.
Clerk probably knows better than I do, but I'll go ahead and try.
We can do one of two things. We can either
Why
put
did you choose
together
a red tie?
a set of photographs or copies of these.
What's on the tie?
Change those
Is
to
it
the
Christmas
exhibits, or
trees?
take the exhibits,
No
copy-
pussyfooting, Eileen. That would be funny if it is. No.
Then I don't know what the record is of what it actually looked like. Not to suggest that you would be involved in any chicanery and switching something out, but just trying as best I can to preserve that record.
Understood. So we probably will not pick them
Okay.
up on this trip, but we will make arrangements to have that done certainly well before trial.
Very well.
Thank you, sir.
Not yet, Miriam.
Speaking of chicanery,
Oh, here we go.
I'm not fond, and you folks know that by now, of making accusations against opposing counsel that are not well-founded and supported by specific actual evidence.
Oh, hey now.
I know that you can get along,
Wait.
but I also know that over the course of a trial, particularly a long one,
Look at Ashley. Okay, go ahead.
What do you think this has to do with? Is this because of that last thing with the records with AT&T? Because remember how he got on?
Remember? Yes, I
Do you remember?
Yes, it was epic. It was epic. What do you mean? Do I remember? It's like stored in my brain forever.
As
One of
an
the greatest moments
officer,
of all time.
as an officer of this court, Miss Taylor.
Yeah. as an officer of the court, are you sure you want to go this route?
Do you think that's what he's alluding to? Because I haven't heard
think
of
that's what
accusation.
he was initially alluding to, saying, as you know, I don't like this, but it seems like, why would he bring that up again unless something else is now coming about?
Now I want to go find out.
Maybe it was a leak. Maybe we didn't hear it, and it was during the closed portion of it.
Don't make fun of my Santa.
I know that you can get along, but I also know that over the course of a trial, particularly a long one, tension. And so I remind you of that to be professional. Don't talk to each other directly when we're in court, right? When the session's going, everything goes through the court as you know, the protocol with courts generally is. Refer to each other by professionally, Ms. Taylor,
Right,
Mr. Thompson,
Tracy?
by first name while we're on the record. Again, avoid making accusations that you don't have the tickets for.
Oh.
Or the receipts for, I should say. And under no circumstances should you make such accusations in front of the jury.
Santa baby.
I was trying not to laugh.
As much as I want you to be flexible
Scary.
about how witnesses are presented. You may have a local witness and a witness who's flown in that needs to get out again at the end of the day. And so it may be that we need to stop one witness's testimony to get the other witness in and then pick the other one up. As long as there's no clear prejudice from that, I'm generally flexible in allowing that so that we can accommodate that. And I ask you to both be accommodating to each other in that regard. All right, any questions about witnesses' testimony?
One is kind of a takeoff of what the court just mentioned. We have at least one, maybe a couple law enforcement witnesses in particular who have testimony relevant to different stages of the case. And it's our intent, with the court's permission, to call them at different times instead of trying to figure out how to call them once and have them talk about what's going on at this stage of the case and then what may be happening next week with the case. Is that acceptable to the court?
Well, let's start with whether it's acceptable with Ms. Taylor.
Your Honor, I don't know that I have a strong objection or really any business in telling the state how to put on their case. That feels really cumbersome to me. I was hoping for leeway the other way when we would call a witness ourselves, but they're a state's witness. I'd hope to have a little leeway to do all of my examination so they didn't have to come back. I would otherwise defer to the court.
Certainly, if you're somebody's on your witness list, if you want to go beyond the scope of direct as part of effectively your case in chief in advance, I don't have a problem with that. And so if it's going to save bringing another witness back, I don't have a problem with that. I don't have a problem if it doesn't get too cumbersome. If we're having a law enforcement talk about a broad area of one phase of the investigation at a time, that's probably okay. But
We saw that
having
in
them come up and narrate
Leilani's.
between every other
Right.
witness is probably too much. Then the question becomes is how do we handle cross-examination? And basically I will defer to the defense on that or the other side on that to the extent that we allow, which is, do you want to cross-examine about the information they just presented now? Or do you want to wait until their last
You
presentation
wait
and cross-examine about everything?
You
So,
wait.
that'll be up to you.
and
With
wait.
that said, then I guess I'd request that the state let us know when they call a law enforcement that's for a limited purpose right now, but is coming back for another purpose.
Yeah, they need to let me know that as well.
Sure.
I think that's a good call all
And
around.
if you don't let them know that, and either way,
For
it's
both
your
sides.
responsibility to ensure that they're back at some point available to the defense so that they can cross-examine, even if you decide, oh, I don't need them anymore. You better not send them on an airplane somewhere where they're unattainable, because the remedy may be to strike all of their testimony as a starting point.
He's like getting ahead of the
Ask
plane
the
trip.
court And counsel if this witness may be excused if we're finished with them. Then give Ms. Taylor or other.
There, and then get it in writing so we have it as to whether or not, for example, Ms. Taylor will need subpoenas to witnesses you have on your list that they want to also call, or if the other way around, you need subpoenas for their witnesses, or whether they will essentially agree to make them available. Anything else with respect to witnesses before I move to exhibits? Okay. All right. So I did require a meet and confer for you to go over exhibits, and I got those, and I appreciate the start that you have on those. There are a number. Appears to be, I can't tell. So for example, there's an objection to, for example, relevance or hearsay. Part of what I wanted to know, though, to start is, regardless of whether it's ultimately admissible for those reasons, is there an objection to authenticity? In other words, I want to make the trial go as quickly as possible. Witness simply to say, this is what this is, and they don't really have any substantive discussion about it. They're just authenticating a document that, if we were to be honest, there's no dispute that it is what it is. And so I may have you go back and look at that and add another column to the list, which is objection to authenticity. Now, some of the stuff, key actual evidence items, DNA or whatever it might be, obviously the defense is entitled to put the state to its burden with respect to chain of custody and all that. So I don't expect that. But on some of the other stuff, certainly to the extent that we can agree that if there's no good faith basis to contest the authenticity, then let's try to do that for everyone's sake. In that vein, I know the state had to withdraw its request to have certain documents self-authenticated to go back and do more work. Where are we at on that?
Oh yeah, I want an update on this, guys.
Your Honor, I believe that we've submitted all of the certificates of authentication for all the exhibits we plan to introduce that way.
Okay. And you've submitted those to the defense to review? And Ms. Taylor, are you going to respond to those?
Your Honor, we did. We met with the state last week, I believe, or the week before, and we discussed some of those records. There were some issues with them. Ms. Jennings provided me with a thumb drive, and I don't know if those have corrections on them, but I'll continue to let the state know what we think, if we continue with an objection or if we're satisfied that rules were met.
Okay. If you could get with each other and then provide me, I didn't study the exhibits that I got a day or two ago or the spreadsheet that closely, but make sure I'm aware specifically of which exhibits there is no objection to the self-authenticating or otherwise not objection to authenticity.
Bye, Shay.
Doesn't sound like we're going to need a hearing on that, at least for the time being, though.
Not that I'm aware of now, but certainly we'll keep our eye on it. I can alert the court, and if we can squeeze it into June 18th, that at noon.
Okay. And then I would certainly caution, at least because the state goes first for now, also, belts and suspenders are good ideas when it comes to trial. So I would have people I need to authenticate things under subpoena, just in case. Especially if they're out-of-state witnesses, because that's not something you can do overnight.
Hi, Shay.
I'm sorry.
So the methods of displaying evidence to the jury, generally there's 3 ways to do that. One is by putting it on the Elmo and projecting the physical document, whether it's a writing or something else. The other is if it's a writing or something else, using litigation software. Use the other 2 approaches as much as possible. Now, they're going to be objects that it may be important for the jury to see, and I get that. But in general, photographs, things that are in writing.
Oh, come on. Cheese and rice. Is he drinking Evian water?
I don't know. Is he being fancy?
I guarantee he's not even wearing pants, Shay.
Whatever. What's going on?
How long was it like this for?
What do you mean?
It's just frozen. Not on my end, their end. What now, more FUD?
Really?
Look at me. I'm jumping. My numbers are going. See my clock at the bottom?
Oh, well, why don't you just drag the red bar until you see it? People move. Oh, there you go.
I could do that, but I just didn't anticipate it being that long. Santa baby.
Now, what's going on?
Take a sip, Hippler. Come on.
Why is it taking them so long?
We could see we wouldn't object to that until
There we go.
phase, but
We're back.
We would in guilt phase, and they aren't clearly delineated at this point. That's something that we could have addressed sooner than not. That would be very helpful.
Any problem with that, Ms. Taylor?
No problem. We did go over that when we met last week, and I identified which ones were for phase 2 if we get there. I don't have a problem stating so that we did make them aware.
Okay. Well, maybe if you can just put it in writing so that they have it, that'd be helpful. That way we don't have any misunderstanding between the 2 of you. Thank you.
You gotta
Once
appreciate
I-
how organized
Once you
he
get
is and
revise
keeping
your
this on
spreadsheets
track.
Based on what we talked about today,
Very.
I'll start about part of what I'm going to do with the time that we have between now and trial is start going through all those, looking at what your objections are, getting my preliminary thoughts together on that, and then we may have another hearing just to kind of go over some of that if I have stuff that I think I can rule on in advance for you, or if I have questions, et cetera. But I'll let you know.
Did you ever watch the Ashley Benefield trial,
Anything
the
else
Black
before we
Swan
move to
trial?
Mm-mm.
Oh, I love the judge from Florida on that. You'd like him. He's like Hippler. He's just like a no bullshit kind of guy.
decisions on
and
motion
very
motions
poised
is,
and has it together.
From the defendant's trial
Judge
brief,
Warner is still my
and that he
favorite.
plans to raise those same objections again at trial. And
Judge
I
Warner?
state that if that's going to
Tisha.
happen, clear the record that
From
the court
Tisha's,
wants
Mhm.
outside the presence of the jury, as opposed to interrupting testimony and presentation of evidence on matters that have already been ruled on by the
So
court.
quiet.
That is acceptable.
I know. His beard's probably getting in the way of the
So
mic.
there's not a need to object again if I've already ruled on the objection. If you're asking me to reconsider, yeah, I think that's something you need to take up outside the presence of the jury, if that makes sense.
That does make sense. And on situations that may arise where we might want the court to reconsider, we'll definitely take that up outside the presence of the jury. I do want to make sure that things such as the model house that was the subject of a lot of objection, that there's a noted ongoing objection to it. I don't mind anticipating that and bringing that up before trial starts and outside the presence of the jury.
And to be fair, you know, I only
Can you
have
try
what
to
is
mute
proffered,
Melissa for a
right? And
second
so
to see if it gets
I have
louder?
in
I
general
want
proffered
to test
that the
something.
testimony will be that it,
And I what?
Mute for a
as I
second to
understand
see if it
that
gets
is,
louder.
Oh, is it my fan?
I don't know. I was gonna see if maybe that may help. Like, it could just be my headphones.
No, I'm sure it will. My big ass fan. Of course it'll help. Hold on.
Yeah. And I asked you to mute it,
consistent
but
with the general layout.
Yeah,
not
2
display,
hours
I think would be
in.
helpful.
do you remember
I have
us
no problem
like
with
going off track on
an
a?
objection based upon what that.
You were on panel yourself, and you were going over this Idaho 4 case. And do you remember where we started talking about um, bed fans and needing airflow? That was like one of the
Underneath the
funniest
blanket.
lives.
I'll
Yes.
never forget that because it's the first time I learned about an under the blanket type of fan, which sounds
Yes.
glorious, honestly.
That was amazing and enlightening.
Yes, amazing and enlightening at the same time. Shay's like, why don't you try to mute? Let me see if that big fan that's blowing into your mic will happen to make the audio sound better. Of fucking course it'll sound better. Why didn't you say that 2.5 hours ago when you started? Like, what the
It's
fuck?
like a wind tundra.
It's literally like, of course, obviously it'll sound better, but how much better is the question? Let me know. All right, let me try this.
Okay, we'll try.
Proffer is actually at the time. And so I think that's fine. I don't think that there's a need for an ongoing objection once that's done, but that helps.
Thank you.
Jury instructions, I
Put it
provided
one
to
in chat
you,
if the sound is
I
better
think
now.
yesterday, maybe pre-proof instructions. Did you get those?
I did not receive those.
Have we not sent those out? All right, I'll send those out
Don't lie, you whores.
probably today or Monday. They're not particularly, I think, controversial. They're pretty stock on the pre-proof. In a capital case, there's a instruction. Normally, what we instruct the jury is don't concern yourself with punishment, the subject of punishment. In a capital case, we are supposed to instruct them under 700B of the capital instructions in the pre-proof
More
phase.
ones, come on.
But it is a capital case, which obviously
Shame
we have
Melissa and
jurisdiction.
her wind
So there's that
tundra
instruction
fan.
there. And what I've done is we're also supposed to instruct them with 700C, which is
It
this
is
is a capital
quiet,
case and you'll have
Maddie's
to
mama.
decide if you find the defendant guilty, what penalty to impose. But then 700C says instruct them in a separate instruction. Don't concern
There's-
yourself with the subject of penalty or punishment in the guilt phase. I've combined those two things together. So take a look at that. I think it reads better than trying to do two separate.
It's
potentially
definitely
contradictory
the
instructions. I think it does it in a way that makes it
court.
more understandable.
Sorry,
Other than that, they're very, very stock
trying to
instructions.
figure out what I'm talking about. Okay,
If
it's
there are other
definitely the
instructions
court
that there's
audio,
not,
guys,
I've
but
included
the
in pre-proof,
fan
for
also
example,
with
stipulations if
Melissa
you want me to
got a
if you have,
double thing going on there.
let me know by submitting a
Fan
request
shamer.
and copying my law clerk on
You
that
need a
as well.
silent fan or something, Melissa.
I think you'll probably get before too long a set of
Shay,
post-proof
the entire
instructions that are
purpose of
very
using that fan is not only for
loose in the sense that
purpose of me
obviously
being hot, but I need sound
based on what I sort of
always.
understand now. But it's helpful
Too
to have a
silent. I can
discussion
hear
about
my
that
thoughts
as early
too
as
loud
possible so that we're all
when it's not
singing
on.
from the same hymnal in terms of what
I'm
the likely instructions
serious.
are going to be. And for better or worse, as you know, the Supreme Court in last year, 2024, revised all their capital instructions. And so in light of that, I will be as much as possible sticking with what they have provided, given that it's clear they've obviously given it recent thought. And so I think that best insulates.
They had a lot of
the
updates in the
case
Idaho
from
law this
perceived error
last
by the
year,
court
even
on
how
the
the
instructions they've recently
defense
given
attorneys
us.
get paid, guys. A lot of changes in their judicial system that got voted in and went into effect.
My
Same,
plan would
Callie.
be, if there
I
is
have
a
one dog defender. I don't like it.
guilty verdict on the any of the counts of murder.
No, let me be clear. I need not just sound. I need sound that produces like a frequency, like a vibration You know what I mean?
That's
So,
why I have my air purifiers. But like if I'm on the live, I'm not going to sit next to my air purifier.
well, listen. Don't you know what, Shay? I've been doing this for 3 years with my box fan. So I don't really care. Okay. It's just part of it. You're just gonna have to accept
I do accept it. It's mostly the core audio, but I think it's just
yeah,
I
don't
think
shame
it's
me because the court feed is low.
I'm not, but I think it was even funnier when you were like, I have to have it on, like even when you're talking to us on a live because of your thoughts. And I'm like, so what would your thoughts really tell us if that fan wasn't on when
Yeah,
you're
you
live?
heard me get a little pep in my step earlier. Now imagine if I was sitting in silence.
With no fan.
Yeah. It's not that wouldn't be good. We're happy to have you here, Tracy. Yeah, I need not just sound, I need radiation. Like I need to feel the buzz. You know what I mean?
The
Now,
butt.
most people use drugs for that. I just use a box fan. Okay.
Your cheap date.
Yeah. I'll take what I can get these days. Okay, let's see.
Would begin
We do
the
triple
penalty
L.
phase as soon thereafter as we can. Certainly probably the next day, unless it's, Friday morning when we get that, then we may not start till Monday or something. But given that the jury will certainly be sequestered during that process, the plan would be to go forward. I also will use as much time as I told you throughout the day to get that accomplished as we can. If that happens and we are in a penalty phase, and there is a finding of aggravating circumstances, or then the court's discretion about which penalty to impose is pretty limited in terms of my discretion. In fact, i.e. none. It's either life without parole or death, right? In that case, I just want to get, before we get to that, defense's position on sentencing for the burglary charge, if they have concerns about sentencing at that time as well, given that it's probably not even a tail wag on the dog, let alone wagging the dog. So, but I'm not going to make you tell me that now, but I will ask you before the jury goes out what you want to do. I'm going to hand you another piece of paper that I would like to get back from the defense.
Love you too,
sometime in
Madison.
late June or early July, which is a declaration of last best offer.
Good night, Dakota girl.
In other words,
Goodbye, babe.
identifying
Love having
whether
you.
the defendant received an offer and whether he has accepted, rejected, etc. Just so that for purposes of post-conviction, we documented that.
Dakota, I don't really buy into it,
Let the,
honestly.
Court reporter know whether you're going to want routinely daily
A lot of-
transcripts or not.
A lot of
You don't have to tell her now, but
Daily versus real time.
so there's two options.
sorry, you want to pause it real quick?
Yeah, no, I was sitting here just talking, but I forgot that it's fine.
Sorry, I was going to answer Dakota girl. I have heard of those theories. That was actually one of the things I mentioned to Melissa. But my thing is that just hearing from professionals, some that I personally know that like work FBI, others that are out here in the YouTubes and other commentators, that according to what we know of the crime scene, the victims, and whatever's happened, that like this like doesn't really fit that type of crime at all. Like that's not the profile that I believe like the FBI was going for. But have I heard about it? Sure, we've heard about everything from Pablo Escobar to tunnels under the houses, but you know, I mean, could something be like a minor thing of a drug something? Sure, but a cartel, that's just it's too far reach for me. I don't really think it fits the victims.
That is right, Leon. That is right.
Mhm.
Truth exposed.
But I think where certain things came about is like I know that there was some speculation that like and I'm not going to talk about the victims' parents or families or those correlations, but like it was a party house. Say they did maybe do some recreational stuff. Maybe there was like rumors of that. I feel like that is kind of like a rumor that like ended up snowballing into that like cartel thing. You know what I mean?
Yes, for sure.
So I think that like some things like they can start as like a more like logical kind of conversation to like theorize about, and then it like gets like blown up into a UFO and alien abduction and wild shit.
They took that inch and ran a few hundred
Well,
miles.
and Kate Scarlett, you're right, and but importantly, like I know where you're from, but be here in Texas, like they are leaving a message when they do that. Like it's, I don't. I don't know. I don't think that there would be any living person in there.
Okay.
And why would, and I also heard the thing like, what if it really was the cartels that did it and they stole Brian's knife? And then that's how it ended up there. I'm like, oh my gosh. Like, even, I've heard so many things tied in.
Exactly, sprinkled dog nut. Yeah, we don't
I
see
feel
that
you.
in here. The one who shall not be named.
None, both, or all, or either. One is I think we can set up real time where you get real time at your table for whatever the charge is from the court reporter for that.
True.
Also, there's the potential to get transcripts each day. I don't think those things are
Oh,
mutually exclusive.
nice.
In other words, you could order both.
Separate fees if I want both. Yeah, make that decision.
It's not now. You may make that as we get close.
Interesting.
Just contact the TCA and she will talk with the court reporters that will be assigned to this to make sure you understand what their structure is, or fee structure. And we obviously need to know particularly about the real-time
Right, Valerie.
events so that we have the technology set up for it. And it may require you to bring some of your own technology in the form of a tablet or a laptop on which it's displayed, right? So we don't supply the hardware, just the software and the actual reporting. Okay. My plan today, as we sit, is to get through the jury selection. I see where we're at
Queen of Hearts.
with the intent that we not sequester.
You just use your Voldemort.
As I explained this morning, the more people talk to the media and the more things that are in the media that are not admissible, whether true
Oh, here
or
we
not,
go, guys.
the more difficult it makes things. And so I'm going to have to
The leak.
figure that out as we get closer. Now, intent is not to do that, but we will have plans in place to revert to that if we have to at any point during the trial. Do either of you want to make a record about sequestration at this point?
I would say the only record right now is that we understand what the court is saying during jury selection. If we still don't know if that could come up, the potential jurors should just be aware that it could come up.
It'll be part of the question that the questionnaire, as well as part of the hardship determination is there some reason they would be unable? I get that they wouldn't like to be, but would they be unable? Do they have a sick family member they care for or whatever, where they have to be home, right? So we'll talk to them about that. Anything from you, Counsel Johnson, about that?
At this point, I understand the court might entertain some things in a closed environment later today, and we do have some sensitive issues to raise at that point.
Oh,
That's my
say
list.
it, Sarah,
Any
say it.
sensitive issues, Giovanna, that you think of? All right, that's my list of stuff, and I know this has been a very sort of nuts and bolts kind of lawyer discussion today, but that's generally the nature of pretrials when there aren't contested motions to discuss, and so that's my list. I'm happy to answer any questions about my preferences or how I handle things that I haven't talked about, or address anything else that you want to talk about. I know we do need to go to a closed session at some point to talk about what will be asked of the jury specifically. I need to avoid that getting out to potential jurors, so we'll do that in closed session. But anything else in the public session we need to talk about?
I believe so, Your Honor. Thank you.
They've already sent out their jury notices to people, guys. Melissa and I watched a clip of that
Public, and we probably take a
on
lunch
our
break
off
and
time
we
a
can
couple
take
months
that up.
ago. So this is a really
I do have a copy. I told you there's
organized
an
event.
administrative order. I'll give you a copy of that just so you don't have to go dig for that. What's that? You've already given it to him. All right, perfect. Thank you.
Sarah, we can have Your Honor.
Sure.
Oh, it's already at hand. Thank you.
Yeah, actually, I have copies of the preliminary instructions for you.
Oh, thanks, sir.
So the jurors, when they got their notice, their potential jurors, they just have a date of when to be here. And so when Melissa and I was saying we watched that clip, a month or two ago. Remember? It was they said that they just have a date, so they don't know, like, those potential jurors coming in could possibly be seated on this case or other cases. So it's not going to be limited that day. So they can't just assume because they have that date that they're going to be on the Kohberger jury, or that it's something else. And I think it's kind of good to think about that when we're considering this leakage kind of talk, that, you know,
Right.
if other people put that together, like, they don't need to be hearing this, seeing this. You don't want to narrow that pool because those notices were sent out months ago. They were very organized. I think that was like when they moved from Latah County, and Judge, since retired after, to being in Ada County with Hippler, almost 7 hours away. He was very, like, on point getting this on schedule, where a lot of, families or other, you know, loved ones of the victims were wanting the justice ball to move quicker because they were 2 years in and they didn't have anything freaking scheduled until we got to him. So he's been very organized and very good at this since October of 2024.
Yep.
In the closed session this morning, I indicated to you I'm going to be entering an order requiring retention of records by the state, and I'm going to write another one extending that to the defense as it relates to violations of the non-dissemination order. I'm going to give you a copy of what that order is going to look like, that I will execute likely over the lunch hour. It does require some action on your part, counsel.
We're going to read that, right?
Yeah.
And as I indicated, I would be open to a request for a appointment of a special prosecutor, and that special prosecutor to ask for a magistrate inquiry, so they have the power of subpoena and the power to question witnesses under oath, as well as the power to grant immunity.
Wow.
So
You hear that?
I will be looking for that from you. And that one just deals with the state. I will be the one that deals with
It's
the
not
state,
just a
the
suggestion,
right?
prosecution team. You're doing it.
All right, thank you. Why don't we come back in about an hour? All right.
And that's where it ends.
Do you want to fast forward real quick and see if it comes back at all?
No, I
Or
did
no?
already. It's not there.
Oh, because that's whenever they're going to do the closed session.
Yes.
Okay. And also, like, one of the things that, like, so the thing that I've seen Melissa and I watched about, like, the jury stuff, it was interesting because they didn't have Judge Hippler being interviewed, but they interviewed other judges. And I guess he's, like, holds some administrative position that he was elected for by his peer judges there. And he's, like, highly respected in that courtroom, or, yeah, in that court building.
So this is the document and records hold order for the state, and then the prosecution one is separate, and it says, based on sensitive information not previously publicly circulated, reported during a recent Dateline TV program related to this case and the defendant Bryan Kohberger, it appears likely that someone currently or formerly associated with law enforcement or the prosecution team violated this court's non-dissemination order. Such violations not only undermine the rule of law, potentially by persons charged with upholding it, but also significantly impede the ability to seat an impartial jury and will likely substantially increase the cost to be borne by taxpayers of Latah County to prosecute this case by extending the time it will take to seat a jury and potentially requiring a lengthy period of juror sequestration. Accordingly, the court finds it is imperative to attempt to see that the source of such a leak is identified and held to account, and that doing so is the best deterrent to future violations. Accordingly, the court finds it's appropriate to exercise its discretion by entering this order. It is hereby ordered that all persons who are at any time, past or present, worked directly or indirectly by employment, contract, consultation, or otherwise, for or on behalf of any law enforcement or prosecution agency engaged in the investigation or prosecution of persons for the murders that are subject of the instant case are hereby prohibited from deleting, discarding, overwriting, destroying, altering, or otherwise making unavailable any, whether electronic or immaterial form,
records, files, documents, metadata, messages, emails, text messages, direct or private messages, phone logs, or logs of communications, regardless of whether made up or kept on a work-owned or personal account, device, or messaging app that in any way relate to a document or the fact of substance of communications with third persons, including representatives of the media or other persons or entities outside of law enforcement, which communications in any way relate to, refer to, or concern the investigation of Bryan Kohberger, the facts or allegations uncovered or reported to law enforcement concerning Bryan Kohberger, or the investigation into the homicides that are subject of the current or then potential criminal prosecution of Bryan Kohberger, collectively documents or singularly a document. That is the longest sentence I think I've ever read. That was all one sentence. Do you
Oh my
realize that?
lord. That's wild.
I feel like you could hear my inflection, like when I'm ending a sentence. I could not end that sentence because it was like my inflection never stopped. Because that was all one long, like from it is hereby ordered all the way down to here was one fucking sentence. Shut up, Samantha. Now I get it.
That's how I felt whenever we were reading a lot of the like DNA sciencey stuff. It was like really winded and big words. I was like, I don't know.
Oh my goodness. All right. Whew. It says all such documents or materials or records that could potentially constitute a document, even if it is uncertain whether such meet that criteria, shall be preserved and must be protected from deletion, alteration, or loss until further order of the court. Any feature on any device or account that is set to automatically delete or overwrite information that could be covered by this order must immediately be disabled. It is further ordered that within 7 days, the state shall submit to the court in camera a list of all individuals within law enforcement and prosecuting agencies, past or present, who are known to have had access to any facts related to the investigation of defendant, including but not limited to surveillance videos of suspect vehicle 1, the AT&T records for Kohberger's phone, and the content of Kohberger's cell phone. Ooh, specifically what's in Dateline. So, suspect vehicle 1, the records for Kohberger's phone, the content of Kohberger's phone, and other electronic devices and social media accounts, including internet search history, photographs, and information associated with Kohberger's Amazon account, or any information referenced in the above-mentioned Dateline episode regarding this case. The state is further required to provide a copy of this order to all such individuals and document that it has done so. Failure to comply with this order may be a basis for finding a contempt of court and such other civil and criminal consequences as may be appropriate. Within 7 days, the state must also provide to the court a written plan designed to address and prevent the future unauthorized disclosure of information related to this case and what it has done or proposes to do to identify any violations of the court's non-dissemination orders previously entered in this case and those responsible for such violations.
Wow. And you already read the defense's one, or?
No, that was just the states, but I'm gonna assume it's gonna be the same, just switched out a little bit at the end. Let's see.
It's different, I think.
No, all that's the same. All that's the same.
The bottom it looks different.
Okay, right here. You could go ahead. It is further ordered, that one.
It is further ordered that within 7 days, the lead defense counsel shall submit to the court in camera a list of all individuals within their team, past or present, who are known to have had access to any facts related to the investigation of defendant, including but not limited to surveillance videos of suspect vehicle 1, the AT&T records for defendant's cell phone and the content of defendant's cell phone and other electronic devices and social media accounts, including internet search history, photographs, and information associated with defendant's Amazon account or any information referenced in the above mentioned Dateline episode regarding this case. Counsel is further required a copy of this order to all such individuals and document that it has done so. Failure to comply with this order may be a basis for finding of contempt of court and such other civil and criminal consequences as may be appropriate.
Oh, so it was the same. Okay. Huh.
Interesting.
At least he's being equal, like he's,
Yeah, you got to look at it from all sides. You can't just
Yep.
assume it could be both, like I said, it could be different sources because that um Idaho, or that interview that Keith Morrison did with Nate Eaton from East Idaho News, he states that him and his partner that he was working with on this production, that they have many sources. I mean, we've heard many sources from others that have reported on it as well.
Mm-hmm. This is just the purpose of this order is to explain the reason for the sealed hearing this morning, held to inform the parties about the orders, to maintain records that the court entered today, and to determine whether a sealed hearing was needed at the end of today's opening hearing to discuss jury selection questions. Okay, notice of amended exhibit list. Okay, that's nothing. Sealing exhibit S1. Motion to reclaim. Okay.
Yeah, I don't think there's a lot. A lot
No,
of things are
there's
more just orders.
formalities.
And then I just sent you like what the case summary is of the schedule. I don't know if you want to show that so people kind of know what's coming out, but that's updated as of today. But yeah, I find it really, really interesting to know that if they're writing this, then my opinion is that there's a lot of more truth to some of the evidence that they have, and I think they should get to the bottom of it.
Mm-hmm.
I'm kind of leaning that it may be somebody who was involved with the investigation early on,
Maybe, yeah.
maybe a mix of others that have obtained stuff, not in a nefarious way, but was like given to them.
It's just peculiar timing.
I think that the stuff about Bryan's records is the most detrimental, in my opinion, based on everything that was out there.
Yes. I agree. You want to go through case summary?
Yeah. So at the end of these, if you haven't been to the site, they have a case summary that you click on, and every day it'll update. So what we know that's coming ahead is May 21st. There's a hearing scheduled at 10 a.m. It's going to be sealed, so we won't get to hear about it, but it's discussion regarding the role of victims. So that's kind of interesting. I'm sure we'll see an order or something maybe come out about that. It could be a little bit redacted. And then on June 18th, that's the hearing that's scheduled to go over the alternate perpetrators. That was some of the what we heard earlier in the trial, that they were requesting that they proffer more evidence towards who they're going to name. And then on, I think it's July 30th. Why did that? Marla makes me think of, I guess Grizzly kept saying June 30th is whenever the jurors are being voir dire, but it's actually July 30th. So into July 30th, that's when they began the jury selection process. That's not going to be live streamed, televised. Maybe there will be some updates from the court on where they're at and jurors they picked at some point. We don't know. But we're to expect that they'll have by August 11th, the jury trial will be in full motion. So that's it. And I'm sure there'll be more stuff that may come in between here based on some of these rulings too.
I just can't believe how close we are, Shay.
Right. And I think it's going to be really interesting what comes out of some of these findings on this special prosecutor for the leak, because if if there is something that's more nefarious or links back to somebody who's still involved in this case, whether it's a witness or investigator or, anybody within the legal realm, that how that could possibly implicate this trial. I mean, that could definitely be a game changer. We saw Delphi, like Richard lost his attorneys right before trial, man.
Yeah, that was crazy.
So I'm like, anything goes. I'm not saying that's going to happen here. We don't know, but I do think that that's something to kind of be alert of. And because it'll be a special prosecutor, a separate judge, like we're not going to probably see much in the docket about this. It's going to be handled elsewhere.
Okay, this hearing scheduled the 18th. The 18th is the alternate perpetrator.
Yeah, that's it.
Cutting it close, man.
Yeah, and
Cutting it close. But
I mean,
honestly, we're still on track, and I love that. I love Hippler making sure this is getting done for the families.
mhm.
Right, it won't be live stream, which makes honestly, Harlan, makes sense. Makes sense. They shouldn't be streaming jury selection. Honestly.
Yeah. And I don't even really think it's like interesting to like watch. Like I do like to hear updates though.
I mean, yeah, if you've seen one, you've seen all. Like, it's pretty standard, actually. But to be fair, a lot of people don't know the process of jury selection and how it
Mhm.
works. So it's good just to know in general. But yeah, and as you heard, Anne, you get Kenny asked about their feelings on capital punishment. Their defense gets asked their questions, prosecution gets asked their questions. They both have an allotted amount to where they could say nope, 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 nope. But then at a certain point, you don't got any more nopes left, and you got to go with what you got to go with. Oh, absolutely, they can, Dawn. Yeah, they can. Yeah, it is strange, Charlotte.
They did. I think the only thing like we did like they have a little bit on, but I don't think it's like you'd have to go over it was they did like an amended order to governing courtroom conduct. But that's just kind of going like how he's gonna, run the courtroom within. I don't really think that affects us. I think he kind of addressed a lot of it in the hearing.
Right. All right. I'm going to hop off and go to sleep because I have to be up in
Okay.
a couple hours, but we will pick our next day this week if you're around this week. And
Yeah.
hopefully nothing else happens until then and we could go back because we need to go back and go over a bunch of things.
Yes, yeah. And I'm like trying to put together a timeline for us and would love to
Oh.
kind of like maybe get your thoughts and do the visual because I really would like to get to the point where we could watch court and kind of track it to like what we know and test it against like what's been
Ooh.
out there. I like doing things like that. Like,
Yeah,
did that
that is
check
fun.
out? You know what I mean?
Yes. Absolutely. Sounds good. All right, let's do it.
All right. Well, good night. Thank you.
I love you. Good night, everyone. And
Love
I'll
you.
see you guys tomorrow for Members Only Monday. Bye.